Recording has begun. Good evening. This is the December 16, 2025 regular meeting of the Complaint Committee of the Sunshine Ordinance Task Force of the City and County of San Francisco. The time is 5:33 p.m. The Sunshine Ordinance Task Force and its committees convene in hybrid meetings that allow for either in-person attendance or remote participation. Public comment will be taken on each item of the agenda. Meeting decorum. Any member of the Complaint Committee may call for decorum due to the disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. I have a reminder for those of you who have joined us via WebEx. Please note we are not using the chat function in WebEx. That is because individuals who are in the room with us live or who have joined us by telephone are unable to see what you are writing. Please do not use the chat function in WebEx. Chair Schmidt, that completes my announcements.
Great. Okay, let's go ahead and go down the list and start with one.
Item number 1. Call to order, roll call, and agenda changes. Taking the roll call. Chair Schmidt.
Present.
Chair Schmidt, present. Vice Chair Stein. Vice Chair Stein, present. Member Sugarman.
Present.
Member Sugarman, present. 3 present. We have a quorum.
Okay.
We have had 2 requests for agenda changes, if I may. Regarding item number 6, file number 25088, we do have a request from petitioner that the item be heard at the top of the agenda due to conflicting schedules for the evening. We also have a request from respondent asking that item 9, file number 25102, be heard along adjacent to item 6, file 25088. They are respondents in both cases. That completes the request that I know of.
Members, do you have any thoughts? I don't know if I see a strong reason. We've had a few requests for agenda changes where the reason was pretty clearly compelling, such as someone's disability or maybe like another hearing in the building. Yeah, member Sugarman.
There's only one item after item 9, like complaint wise. So if it's a request by the respondent, then it depends on what the timing is for everybody, but I mean, you could move item 6 downward.
6 wants to be done by 6:30, I believe.
Oh.
That's their request. So the 2 requests are a little bit, 6 is the third after the 2 Turon cases. So we could, jump 6 up and then do the Turon cases.
But then you would be doing 6 and 9, right? That's the request, is to move here 6 and 9 together.
Yeah, I wouldn't want to jump 9 ahead of the Turon cases. I know they have 2 cases on, but there's no enunciated reason that I got for their request.
And it's a big schedule too. It just doesn't feel necessarily there's a fairness to the other parties.
I mean, I don't mind going 6 Turon, and then the other mayors. Okay, since the mayor has 2, and so the mayor would then get out of here a bit earlier. So we jump 9 up to behind the 2 Turon cases. What do you think? Any okay. That's what I'm going to do. In order to respond to both requests, let's hear 6 before we hear 4 and 5. So it'll be 6, 4, 5, and then we're going to hear 9, 7, 8, 10. Yeah. And I don't know if I need a motion for that.
That's 6, 4, 5, 9, 7, 10.
6, 4, 5, 9, 7, 8, 10.
8, 10.
Yeah.
All right. Public comment?
Well, he didn't do a motion, so I don't, does it need public comment?
I don't know if I need to make a motion to rearrange the agenda. Is Victor around?
Mr. Young?
In general, you don't need a motion to change the order of the agenda, but it can't hurt to ask for public comment on it.
Okay, that's fine. Sounds good.
Anyone wishing to make public comment on the proposed order in which the agenda items for the evening will be heard? Please come forward to the podium or raise your hand in the app or press *3. I'll give you a moment. We have no one at the podium, no hands raised.
All right, let's vote. Oh, we don't need to vote. Sorry. Okay. So it looks like we can go to the next item.
Item number 2, approval of the November 18, 2025 Sunshine Ordinance Task Force Complaint Committee regular meeting minutes.
Members, any changes? Yes, Member Stein.
I had in my notes of the meeting that, but I'm not sure, maybe it doesn't comport with yours, but under item 9, it was you moving, Chair Schmidt, with Sugarman seconding to send something to a consent calendar and find no violation. And I had in my note, that a thorough search seems to have been performed on time, though no records were provided. And I'm wondering if we wanted to include that, because usually we give a little bit of direction when we send something to the consent calendar about what's going there, so that people understand our reasoning. But I had it in my notes. I don't know if it was just my thinking, but usually I take the notes based on what was said.
Let's add it in. Yeah. Let's just, why don't you go ahead and put it in?
So just, it'd be an addition.
Can I have a restatement, please?
Yeah, a thorough search seems to have been performed on time, though no records were provided.
The committee further noted that a thorough search seems to have been performed on time, though no records were provided. All right. Are there any other changes?
I don't think so. So let's, I'll make the motion to approve the minutes with the edit that was just discussed.
I'll second that.
Moved by Chair Schmidt, seconded by Vice Chair Stein. Taking public comment. Anyone wishing to make public comment on item 2, please approach the podium or raise your hand in the app or press *3. We'll give you a moment. We have no one in the queue. Taking the vote on item 2. Chair Schmidt.
Aye.
Chair Schmidt, aye. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Member Sugarman.
Aye.
Member Sugarman, aye. 3 ayes, motion passes. Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda. Please step forward to the podium if you wish to make public comment, or raise your hand in the app or press *3. We have no one in the queue.
Okay. Let's go on to number 6 next. If I'm correct, 6 was what we set forward.
Item number 6, file number 25088, complaint filed by Rich Sanders against the Office of the Mayor for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a public records request in a timely and/or complete manner. One moment, please. We have a representative from the mayor's office. Mr. Darmali, promoting you to panelist. Mr. Sanders, if you are present in the online community, please raise your hand in the app or press *3 so that I can identify you. Hello, is this Mr. Sanders?
Hi, I'm here.
I'm promoting you to panelist. You'll be able to mute and unmute yourself. One moment, please. Chair Schmidt, the parties are present.
Okay, thank you. So we have seven matters tonight, and this is the protocol we're going to follow. We start with hearing from the parties. We give you 3 minutes each, petitioner first, then respondent, to tell us about the case, whatever you want to tell us for up to 3 minutes, bearing in mind that we've already read the files, we've already had the opportunity since everything was submitted to read the files. After those, the members of the committee may or may not have questions to ask of the parties. So that's going to be the questions to parties period. And then after that, we will deliberate and determine what we want to do with the case at hand. The committee does not make any final decisions on any case. We look at issues primarily of whether public documents or meetings are involved. We look for jurisdictional questions. We look to determine if a case is ready to send on to the full task force for hearing and determination. We may make recommendations. Often we will send a case forward with or without recommendation. We also, in certain cases, may put something on to the consent calendar for the task force. So there you go. With that said, let's go ahead and start. When our administrators ready with the timer, let's start by hearing first from the petitioner in this case.
Mr. Sanders, are you ready for your 3 minutes to begin?
I'm ready.
Your time begins now. I'll give you a 30-second warning.
Thank you, and thank you for bumping this item up. I appreciate it. So yeah, as I'm sure we're all aware, the President of the United States has initiated a terror campaign against our immigrant neighbors. Earlier this year, the mayor reportedly had a conversation with the president, after which the president decided not to send the National Guard and other law enforcement into the city. This is obviously a clear matter of public interest. So as a result, I requested a swath of documents broad enough to capture any kind of communication, memo, record of the conversation, meeting, or any document related to any decision that occurred, including things like phone records, transcripts, name of participants on calls, all kinds of stuff. The mayor and city attorney's office responded saying that this is the documents are privileged because the city attorney is copied on them. I want to note two things that I think make it pretty clear that this is not a complete production. The first is that the city attorney can't reasonably be copied on absolutely everything, including like non-emails, right? There are all kinds of requests here in which a CC is not a concept that really makes sense. But the other is that First Amendment law is pretty clear. I included this in my documentation with a citation from the First Amendment Coalition, that the courts have found that not everything that passes an attorney's desk is covered by this privilege. In order for it to be privileged, it must be made for the purpose of legal consultation rather than some unrelated or ancillary purpose. The mayor would have us believe that every single record I requested is made for the purpose of legal consultation. This doesn't make sense. Doesn't make sense to, I think, a reasonable observer. So I would ask the SOTF, ask the mayor's office what kinds of records exist, how it could be possibly reasonable that every single one of them is exempt. And if there's not a reasonable answer to that, this be found a violation, because it's just clearly not a complete production. And I just really want to point out, theoretically, the mayor could just CC the city attorney on everything if this is the case, right? And just not produce any records, thus rendering this sunshine law entirely moot. Do you want to say there's a long history of San Francisco mayors devising new and creative ways to do that, to circumvent public records law, previously destroying records, now simply claiming none of them are disclosable in the first place because we're CCing the city attorney on all of them. So that's the issue there. I appreciate your time.
Thank you. Member Stein.
Number 7.
We're on
Number 6?
6.
Was he not
Standards.
the Trump and Lori?
Oh, did I get the?
Really? And maybe my thing's mixed up here.
What? 1 second. We're just trying to clarify something for the members. This is Sanders versus the Office of the Mayor.
Maybe I just have it numbered wrong, so that's fine.
Okay.
Okay,
25088, correct?
correct.
Okay.
All right.
Got it. Yeah, my numbers.
Okay. So now when our administrator's ready, we'd like to hear from the respondent.
Mr. Darmali, are you ready for your 3 minutes?
Yes, thank you so much.
Your time begins now.
Good evening, everyone, and thank you so much to the complaint committee members and the staff of the complaint task force. I know how much work you put into this, and I really appreciate this, and I know everyone in the mayor's office does as well. So this complaint in front of us with Mr. Sanders is concerning documents. The documents that could potentially be responsive to this fall under attorney-client privilege. And the reason why we're able to say this is because this complaint was also forwarded to the supervisor of records in the city attorney's office. And they, as a third party to this, had independently determined that the documents that could be responsive to this were withheld properly under city and state law. And beyond the documents that do have attorneys included in consultation, there are no other documents that are being withheld. So every document that could be responsive to this request is withheld under attorney-client privilege. I mean, the mayor's office, I oversaw this request, and I responded to Mr. Sanders saying, hey, this response, we responded within 10 days of receiving the request with our determination that we had no responsive documents or that we were withholding documents for the attorney-client privilege. And beyond that, we still continue to answer Mr. Sanders' questions after we close this request. So, I mean, this was our demonstration of a good faith of wanting to explain how we got to this point. So I think I also want to just set the framing of documents that are privileged. The contents or what they're necessarily about is something I'm not able to discuss today, and I hope we can understand that because that's attorney-client privilege. And beyond that, I think there have been a lot of steps leading up to this point where the mayor's office has tried to remedy this, and explain why these documents are being withheld. So I hope we can see that as well in these documents. And with that, thank you all so much, and I very much appreciate and look forward to your questions.
Thank you.
All right, thank you. Members, we're now going to the question answer period. Members, do you have any questions for the parties?
Oh, okay, I can ask a couple questions. These are, I think, mainly for the respondent. Could you tell us, before you determined everything was attorney-client privileged, was there a search process invoked to look for documents that might be responsive?
Yes, so when the mayor's office received this request, I went to our team and I said, this is our request. Do we have documents that are responsive to this? So we did have a search process. So this was not an automatically, if this is a topic, we do not have documents. That was not by any means the procedure that was taken here.
Okay, and were any documents provided at all?
So no documents were given for this request. Either we had no responsive documents, or the documents that could have been responsive were withheld for attorney-client privilege.
Either you had no response, so you don't know if it was that you had no responsive documents or whether you had documents, but they were withheld.
We withheld documents for
Okay.
attorney-client privilege.
Okay, those are my questions.
Okay.
Member Sugarman.
So, and this is something also that I will shortly in deliberation defer to Chair Schmidt, but my question is, the first two parts of the request are the date and time of the phone call and the participants on the call. And in my non-legal understanding of privilege, that's not necessarily a type of data point that's part of attorney-client advice. And so my question to you is, was there a search for that specific information? Was there a consideration to provide information that was not privileged, but perhaps was on a document with privileged information, but you could have redacted that privileged information? Was that a consideration?
So we looked at all the documents. Our team looked at all the documents at the time that this request came in, and it was determined that everything here was attorney-client privilege. And I know the phone call records. I know I saw that as well, and I thought, okay, well, we must have something that we can't produce. But when this request came in, we did not have a responsive document for that.
Okay. That ends my questions.
Okay. Question. This is Chair Schmidt. Question for the respondent. I'm looking at a November 6 document from your office, which says it's something that talks about the attorney-client privilege. And it says attorneys from the San Francisco City Attorney's Office are on documents that could be responsive to your request. But the Office of the Mayor is withholding them because of attorney-client privilege. Is that the standard that your office used to determine what's attorney-client privileged?
So that message that you are referring to is me responding to Mr. Sanders' follow-up question, and that response is beyond what the ordinance requires us to do, just so that I think we're level setting there. Like, this is our office explaining what this attorney-client privilege meant. But I mean, I think your question is, what is our office's understanding of attorney-client privilege? That's attorney work product, attorney input, the attorney being involved in the process of the document.
What does it mean when you say attorneys from the city attorney's office are on documents? What does that mean, on?
So
Just a word.
this,
What does it mean, on?
So this message was explaining attorney-client privilege. The attorneys are involved in the documents that are being withheld. So that creates attorney-client privilege.
Okay. Now, Member Stein asked you if you did a search for records. And it's my understanding that you said, yes, you found records. And then there was a determination that all of those records fall within privilege. My question is, how many pages of records did you review to make those determinations? Or did anyone at the mayor's office review which were pages of documents that were responsive?
So I don't know that answer off the top of my head.
Did you do any of that review?
So the documents that are attorney-client privilege, I'm not at liberty to speak about in specific, if quantity, number, contents.
But the documents, you can't tell us how many documents there are that you claim attorney-client privilege for. Is that what you're saying?
I'm saying I cannot give you a good faith answer about the number of documents that there are.
Okay, how many?
I'm saying I can't tell you right now how many documents there are on one hand, simply because I don't have that number. And on the other part of it is these are privileged documents, so I'm not at liberty, if I did know that number, to discuss it.
Okay. And how many documents did you review yourself and determine that they should not be produced because of attorney-client privilege?
So I showed the request to my team members that could have potentially been involved. They looked at it, and it was determined with them that like these documents the city attorneys are involved with, they're on. This is attorney-client privilege. So I worked with my team closely in the mayor's office, so I wasn't there with every single page, but I explained like what attorney-client privilege means here. So there was a long explanation of the steps that would lead up to us citing attorney-client privilege for the reason to withhold these documents. So so it's about there was a well understood definition when we were looking for documents, like what we can consider attorney-client privilege, and what we cannot, because we knew that this was a request of great public interest, and we also understood we wanted to stand by the Sunshine Ordinance and produce what we needed to produce.
You said there's a well understood standard that was used. What's that standard? Is it this on when the city attorney's office is on a document?
So it similarly to what I mentioned, when it is attorney work product, the attorney is like they're in collaboration, like the attorney is involved in the process of the document.
Okay, now, how could any of these documents be attorney work product? You're talking about attorney work product now. How could any of them be? Because these are not city attorney's documents, as far as I understand. We're asking for mayor's office documents. How could they possibly be attorney work product?
So I hope that we could understand that because of the nature of the what was occurring at this time, the city attorneys were brought in for consultation on all of these items.
And that
So-
turns it into attorney work product.
So if it is asking attorney advice, asking attorney opinion, there are many ways that we can get to attorney-client privilege, which city and state law allows.
Okay, thank you. I have no more questions. Members, any more questions? Otherwise, we can deliberate on this and figure out what we want to do with it.
So I'm just going to reiterate that I don't have a law degree, so I can't speak conclusively about what is attorney-client privilege. However, looking at the list of things, I found your last question quite compelling about attorney product. Even in that case, again, in my layman's understanding, it would still have to rise to the level of advice, even if the attorney produced it. Like if they were just creating something that was about the facts of the phone call, then the advice is like the privilege. Is one thing that I want to suggest. But moreover, if I took away any of that, the first two bullet points, the date and time of the phone call and the participants on the call, do not seem like they should be privileged to me. And the rest of it, to me, feel as though you could claim that. Like if it was emails, texts, or memos with the mayor's office, because if I were a leader in this position, I might consult the city attorney about any of all, I might before the phone call happened, I might have talked to my attorney about that. So that seems like it could have been attorney-client privilege. But I still feel like if I wanted to get something from this request or where I'm looking for violation, I would say that I would want them to produce the date and time of the phone call and the participants on the call.
So I'm wondering, from the perspective of someone who knows more about attorney-client privilege, suppose offices from the federal government reach out and ask for something. And suppose the mayor's office has an attorney review that before they give a response. Would that incoming communication to the mayor's office, be attorney-client privilege because an attorney looked at it and gave
No.
advice based on it?
No. The communication between the mayor's office and the federal government is not attorney-client privileged. I can't imagine any scenario that's not privileged. My thought is that there are probably some aspects in the documents that were requested here where the privilege could apply. Certainly some aspects where it's a communication, it's not set outside of the communicating office, which is the mayor's office, and the city attorney's office or outside counsel. If the privilege is preserved and it's a communication designed to obtain advice or to give advice, yeah, that's attorney-client privilege. But the terms of what was asked for here, there's a lot of information, as Member Sugarman noted, that it's not like you can. It's not like you can add the attorney's name onto documents and then claim the privilege.
Or just because an attorney reviews a document that you received to give their advice, that doesn't make that document privileged.
No, absolutely not.
That part I want to ask from your review of the documents of this file, because I saw the petitioner say the words like CC or a product of the city attorney's office. I'm not sure I saw that in the respondents. The respondents seemed to just say they just claimed attorney-client privilege and kind of left it there. We don't have responsive documents. So it was only in the questioning that I was listening to where they were saying it's a product of the city, the attorney's office. So that's the part where where I didn't hear, other than in the petitioner, say about like the attorney was CC'd sort of thing. I didn't see that in the respondent saying that. But they did say that they were part of the production of all of the documents, which to me, even if that's true, like in my mind, it's like, well, then we call it strains credibility a little bit. But if it happened that way, where it's like we called the attorney's office and they typed up the document, even if that happened, to me, the date and time of the phone call and the participants on the call are not privileged information. Like that data comes from elsewhere, even if they produced the document in the city attorney's office.
Yeah.
So if the attorney says, oh, this is how you should respond, and then you write a response, or even the attorney writes a response, and then you send it to the federal government, like that is no longer attorney-client privilege.
Not that,
It's been made public.
whatever was sent is not. So if there were any written communications surrounding this phone call between the different offices, that's just, there may be some other protection, but that's not attorney-client privilege and it's not work product. It's not. I saw at least two instances here where this use of the word on, it sounds like what they mean is, oh, if you see the city attorney's name on a document, then it's attorney-client privilege. It looks like that's a test that they applied when they were doing this review. And then there's the part of like, oh, they were part of something. That's not enough. And so I don't know if the city attorney's office would have given them that type of language as a way to, make a determination about what's privileged or not. I doubt it, but that would not be accurate advice if they did. And it looks like they applied some standard that I just don't see it's certainly not the kind of standard that you need for attorney-client privilege. Now, in terms of work product, I didn't know if they claimed it here, but I'm hearing about work product here today. Work product it's a separate thing. I can't imagine that anything here would be work product. Work product it's actually attorney work product. So it's usually something held in the attorney's office, and it's what they work up when they're representing a client. Now, if Mr. Sanders went to the city attorney's office, that's where the work product really stands. There might be a little bit of work product at the mayor's office because it's, a copy is given to them, but generally they're not going to have any work product outside of what they have that they got directly from the city attorney's office. And that's probably privileged anyway. So it's privileged and work product protected. So I think there's got to be information in whatever documents were requested here, because the request here was written pretty well. Mm-hmm. And the contents of the request indicate to me that there's a lot of things that are requested that I can't imagine, if it does exist, it's privileged. Mm. So I think that we would be, we can't make any decisions here today, but I think we at least should recommend to the task force that we find that they, by applying the tests that they did, they violated the ordinance, and we order them to redo their process with the correct standard.
I think that sounds right. I just want to say that it does seem hypothetically possible that they say, I'm going to have a call with the president, and then the attorney prepares a statement. Do I know that happens? No, but like that would still, to me, I don't know if that makes it privileged, but like audio recordings or transcripts, I feel like that is work product by the attorney's office at that point. I don't know if that's privileged, but like I do think there are other factual pieces that they still could be releasing if they're not releasing that.
That's, that to me, I don't know which way you go on that one. That could be privilege and it could be work product also. If it's not used.
Mhm. Oh, but if it's used, then it's public because
Yeah. If it goes out on the airwaves, if it goes into a conversation,
okay.
and if they tape record that conversation, there again, there may be other ways that you protect that, but it's not the attorney-client privilege because I don't think the mayor's a lawyer, and he's certainly not Trump's lawyer as far as I know. But weirder things are happening than that. Yeah. Okay. So I'm going to make the motion. I'm going to move that. I think this should go before the task force. We could put this conceivably on the consent calendar, but I'm not going to do that. I'm going to move that we forward this matter to the full task force for full hearing as soon as possible, with the recommendation to find violation by applying inappropriate standards for withholding privileged documents. And also that the respondent be ordered to apply the correct standards in a second attempt at responding and produce all non-privileged documents.
Okay.
May I ask a question?
I'll allow a question. Yeah.
So if our attorneys are telling us documents are privileged and to withhold them, what would the task force like to see from that?
Well, I don't know if we are trying to delve into your actual communications with your legal counsel. That's not exactly what we're trying to get at. We don't want to hear what you were advised about the search. It sounds to me, the way you described your search, that you had people in your office who were going through documents and applying some standard to figure out what's privileged and what's not. And so that, to me, that's not something where it's the city attorney's office is making a decision on a document. If the city attorney's office actually made the decisions on all these documents, that's a different thing. And we're trying to ensure that you apply the right standards, which is, it's set forth in the law as to what's privileged and what's not, and to produce any part of a record which is not privileged as the Sunshine Ordinance requires. So that's just what we're looking for. So I can't tell you what you can tell us about your discussions with the city attorney's office. We can't compel those kind of communications from you. On the other hand, that's your call because you're the client of the city attorney vis-a-vis those communications. Yes, Member Sugarman.
We can advise, though, the respondent there will be a DCA there. They could talk to that person before the meeting.
Are you talking about our DCA here?
Mm-hmm.
Well, that's a DCA on our side of the ethical law.
Okay.
And they have their own section of the city attorney's office. And they're really there's really a wall between them.
Okay.
Yeah.
I'm just curious, like, I'm wondering based on the respondent's question, like, hypothetically, would it satisfy us if they got a letter from the city attorney's office saying we reviewed all potential responsive documents and we feel that every single document we reviewed falls under work product privilege or attorney-client privilege?
Well,
May I say something to that?
go ahead quickly.
I think that exact type of document does exist and is in the records in front of you. When the supervisor of records has reviewed these records and has determined that documents that have been withheld were withheld properly according to attorney-client privilege. So that type of document is in front of you.
Thank you. And I will just say that we have no reason to think that supervisor records did a review for privilege. We don't know what they did, and so that doesn't answer our question. To Member Stein's question, I think that if we were told that they had the city attorney's office review everything, and the city attorney's office made a determination that everything is attorney-client privileged, that might change what we would do here. That might make it a different ballgame than what we're seeing here today, because it appears that is not what happened actually. Now, if they were to come back to us and say, city attorney's office, we went to them and they confirmed by looking at the documents that it's all privileged, that may be something that we consider. I'm not saying that's like 100% compelling to us, but it could be something that could be important to members. And it's up to each individual member of the task force how they weigh that. Did I answer your concern, Member Sugarman?
Yes,
think
I agree with you. I would be more interested. I'm going over what the respondent said to see if there's something that satisfies that, but it seems to me that I would be more interested in seeing the same letter that Member Stein suggested from the city attorney's office. Because I understand it sounds as though what the respondent is saying is their hands are tied, and I would like to see that in writing.
Okay. All right. Well, I've got a motion. Did that motion sound secondable to anyone?
I second.
Moved by Chair Schmidt, seconded by Member Sugarman, to find that the task force has jurisdiction, that the requested records are public, and to refer the matter to the full task force with the recommendation that the office of the mayor violated Administrative Code Sunshine Ordinance Section 67.21 by applying inappropriate standards for withholding privileged documents, and that respondent be ordered to apply the correct standards in a second attempt to respond and to produce the documents. Taking public comment, if you are in the room, please approach the podium. If you're online, please raise your hand in the app or press *3. We have no one in the queue. Taking the vote. Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. 3 ayes, motion passes.
Okay, so that will move on to a hearing fairly soon on the with the full task force. Thank you to the parties.
Thank you, parties. Item number 4, file number 25064. Complaint filed by Michael Turon against the City Attorney of San Francisco for allegedly violating Administrative Code Sunshine Ordinance Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. We have respondent present. One moment, please. Checking for Mr. Turon online. Mr. Turon, you have been made a panelist. You will be able to mute and unmute yourself. Parties are present.
Okay, let's go ahead. When our administrator is ready, let's hear first from the petitioner, Mr. Turon, for up to 3 minutes.
Mr. Turon, are you ready for your 3 minutes? Mr. Turon, you're unmuted. Mr. Turon, can you hear us? We also have Mr. Turon's counsel present. Would you?
Yeah, unmute them too. I think it could be either who would speak.
Thank you. This is Samuel Ray. I'm here on behalf of Michael Turon. I was trying to raise my hand and become a panelist.
Got it. Great. Okay. Thank you. All right. Are you going to be presenting these matters today?
Yes, both item number 4 and number 5 on behalf of Mr. Turon. Thank you.
Okay, great. Okay, there we go. So when we're ready with the timer, we'll hear from you on 064 first.
Thank you. I'm ready whenever you are.
Your 3 minutes begins now. I will give you a 30-second warning. Your time begins now.
Thank you. Members, my client was the subject of litigation where he was the plaintiff with the city and county of San Francisco. That litigation concluded with the dismissal on July 7, 2025. Thereafter, my client filed a sunshine request requesting the billing records from the underlying litigation matter. Some limited records were produced, or sorry, strike that, no records were produced. My client sent follow-up correspondence, including a demand letter. After that, the city refused on a blanket privilege basis to provide any documents. We believe those documents are subject to the Sunshine Ordinance. Specifically, there's a case on point, County of Los Angeles Board of Supervisors versus Superior Court, which states that fee tolls and billing amounts in concluded litigation are not subject to attorney-client privilege. Again, the city attorney blanket privilege over every document in the file. We agree that while legal advice contained in those billing records may be subject to redaction, limited redactions under the Sunshine Ordinance, the amount of public funds spent, the dates of service, the identities of the payees are non-privileged facts. The Supreme Court has made that clear, our California Supreme Court. The public has a right to know the cost of litigation, and the city's refusal to segregate those physical figures from the narrative constitutes a violation of Sunshine Ordinance Section 67.26. Additionally, the city refused to provide any sort of basis for the withholdings aside from the blanket privilege assertion. I believe that violates Sunshine Ordinance Section 67.27. In email correspondence, the city stated that they would not be providing disclosures for the individual documents. That also violates the Good Government Code. The Sunshine Ordinance is mandatory. It requires some sort of assertion of privilege with respect to the individual withholdings. It also requires that withholdings be kept to a minimum. The city's basis for withholding these documents was pending litigation. Under the government code, litigation records are only exempt until the pending litigation has been fully adjudicated or otherwise settled. This matter was subject to a settlement, and the case has been dismissed with the court retaining jurisdiction. The assertion of the chair is unwarranted. The privilege lapsed when the litigation was concluded. Likewise, my client asked the city to appoint a neutral custodian to review the Sunshine records. The city refused to do so and instead relied on litigation counsel to do so. Again, that's a violation of Sunshine Ordinance Section 67.21I, which is designed to prevent a conflict of interest. We ask that the Sunshine Ordinance take this matter up for consideration.
I see that concludes your time.
Thank you.
Thank you. Okay, so next, when the timer is ready, we'll hear for up to 3 minutes from the respondents.
Ms. Quart, are you ready for your 3 minutes?
Yes, yeah.
Your time begins now.
Okay, thank you. Good evening, Chair and members. Some background on this litigation. The complainant filed litigation against the city in 2021 related to an unauthorized dwelling unit on his property. The city and the complainant came to a settlement agreement and a stipulated injunction in December of 2024. The settlement required that the complainant do many things, but a couple of things of note. It required the complainant to dismiss the case, to take a certain corrective action, including construction of a new unit in his backyard, and pay the city $400,000 in damages if he did not build the unit. The settlement also required that the new unit would be subject to the city's rent control ordinance, and the complainant would record a notice of special restrictions on the property to that effect. Initially, the complainant did not dismiss the case, requiring our office to issue a notice of breach. Complainant eventually did move to dismiss, and the court entered a notice of dismissal on July 7th. But the complainant did not record the notice of special restrictions until November of this year. And the complainant made substantive changes to the notice of restrictions that we do not believe complies with the settlement agreement. Complainant has also taken the position that he does not need to comply with the rent control ordinance despite the settlement agreement. There is an open question about whether the complainant will honor the settlement agreement, and the court has entered an injunction against the complainant that remains active. They have retained jurisdiction to enforce the settlement agreement. We have attorneys currently working on this matter to ensure compliance with the settlement agreement. And the complainant has also filed another related lawsuit against the city in state court. So this matter is far from resolved. Getting to the records request, the complainant sought 4 categories of records. The first was any letters to outside counsel retaining them. We did not use outside counsel in this case, so those records do not exist. Next 2 categories are attorney billing fee information and as well as invoices and statements of the city's costs and expenses. The case that the complainant cites is actually says the opposite. So the Los Angeles County Board of Supervisors held that attorney billing records, such as these ones at issue, are subject to attorney-client privilege. They say that the nature or amount of work occurring in connection with a pending legal issue, quote, lies in the heartland of the attorney-client privilege. And then my time is up, but I'm happy to take more questions.
Okay.
Thanks.
Thank you.
Thank you.
Okay, members, now we move on to any questions. Member Sugarman.
I know this is in the packet, but I'd like to hear the respondent complete the rationale for why the documents were withheld. I know you were going to
Sure.
this.
Yeah. So on the categories, what I would call 2 and 3, attorney billing fee information and the invoices and statements of the city's fees and costs. So these we withheld under attorney-client privilege, and we cited the case Los Angeles County Board of Supervisors versus Superior Court. And I just read that quote for you. But this privilege and this withholding applies even if the information is more general. So an aggregate number, essentially describing the total amount spent on litigation during a given quarter or year. The only exception to this is the only caveat to this rule is if you give a quote unquote cumulative amount spent on quote unquote long concluded litigation. And basically, if there comes a time when the information that you're providing doesn't shed light on the underlying legal issue or shed light on how the resources you spent on a certain case, and it doesn't provide any insight into litigation strategy because the matter has been long concluded. And our office does, as a practice, we share cumulative cost totals in response to public records requests on lawsuits that have been long concluded. But this matter is not long concluded, and I would say it's very much active.
Right.
And then there is one other category of records, if you'd like me to go into that.
Yes.
Okay. The fourth category that they were seeking was basically case closure settlement memos. We feel that these are squarely within attorney-client privilege and attorney work product. That would be something that we would prepare for our clients. It would contain a great deal of legal analysis, and so we withheld them on that basis.
I guess I have a question about that. That does sound like it's confidential, but typically that depends if the settlement actually is confidential. So,
well, I think I can say this as a practice. So this settlement went before the Board of Supervisors, and they, as many of our settlements do, and they approve them. Any settlement that's going before the Board of Supervisors, we prepare a confidential attorney-client privilege memorandum to the members of the board, giving them the rundown of why we got here, basically, and what we think the legal issues are.
okay, and that's what they were seeking. Okay.
Yes.
Thank you. That all helps. Thank you so much.
Yeah, no worries.
Ms. Court, if you could, just a couple questions. Okay, so how long does the injunction last? Is there a time period?
I don't know that answer. I can let you
Okay.
know when we get to the full.
It's still in force right now?
Yes.
Okay.
Yes.
And you said, both in writing in here, that the court retained jurisdiction, and that's just for purposes of enforcing the settlement agreement?
Correct.
Okay.
Correct.
Which court, which judge, do you know?
I don't know who the judge was, but I believe this litigation was in federal district court. And then the complainant has another somewhat related matter in state court.
In state court?
Yeah.
Okay.
I think I have the case number if you're interested in that.
No, that's okay.
Okay.
That's all right. The last question is, you said there's a dispute over the notice, the content of that notice, and that's an ongoing dispute, right?
Yeah, so I would say the complainant, the court issued a notice of dismissal of the case in July, but the notice of special restrictions on the property wasn't filed and wasn't recorded until I believe November of this year. And from our perspective, there are changes in that notice of special restrictions that we do not believe comply with the settlement.
Got it. Okay, thank you. All right. Members, any other questions? Okay, I think we're done with questions. I will say, just because I'm maybe, unless you all are involved in hundreds of lawsuits, I don't think you are, but I've probably got a little more experience on this kind of thing. It does sound to me like the most important thing is this case. It's not like a money damages case where you settle it, a check is written, there's a release, there's a dismissal, and there's nothing else to be done. I think that there probably will be disputes. It seems like there's several potential things that could go wrong here. And so this is even though the merits of the case before the judge, the complaint itself was resolved. It's the enforcement of that settlement agreement which resolved the case. Those are still active issues to me. So I think we could say pretty clearly that they're active within the scope of the litigation. So I don't think would fall under this County of Los Angeles case. And so I don't think that any of this is obtainable information here. Maybe if it was one of those more simple cases, sure. It may be 2 years from now, sure, but certainly not right now. That's my thought on this.
I would just add the judgment itself seems to recognize that this is not the end of potential dispute.
Absolutely. Good point. Good point. Yeah. I know we've got another matter that totally, it looks like there's a lot of different issues with Mr. Turan coming up, but at least for this one, I think we could even do this as a consent.
Yeah.
Okay.
Mm-hmm.
Okay. I'll be the since it's always all about me, I'll make the motion again that we I'll move that we recommend that the task force make a finding of no violation and place this on the next available consent calendar. Yes.
Can you add the rationale for that in that motion?
Sure. I'll just tack on a sentence. The dispute that the parties have litigated is an ongoing matter before the court. And so County of Los Angeles does not apply. Is that all right?
Is it also that the reasons for withholding do apply?
Would you please use the microphone?
I'm just one,
Sure. I'll tack that onto the end of that sentence, and the reasons for withholding do apply.
Moved by Chair Schmidt to find that the task force has jurisdiction, that the requested records are public, and to refer the matter to the consent agenda with a recommendation of a finding of no violation. The committee further stated that the dispute that the parties have litigated is an ongoing matter before the court. And so County of Los Angeles does not apply, and the reasons for withholding do apply.
Perfect.
I will second that.
Seconded by Vice Chair Stein. Public comment. If you have public comment on this matter, please approach the podium if you're in the room. And if you're online, please raise your hand in the app or press *3. We have someone at the podium.
Good evening, Task Force. Haven't been here
Just
for
a
quite
moment,
some time.
please.
Sorry.
Time?
3 minutes.
You have 3 minutes. I'll give you a 30-second warning. Are you ready?
Yes, thank you.
Your time begins now.
I'm walking in here blind, just at one of the other meetings, and I just want to point out that there is case law. I'm not familiar off the top of my head with LA County case, but there is case law that goes to the issue of once the litigation has concluded, taxpayers have the right to access. Now, they can go, for example, with the San Francisco Superior Court, they can go online and they can find, if they are diligent enough, they can find a lot of the work product that the city attorney generates or deputy city attorneys that are taxpayer funded. That can be backed up by Code of Civil Procedure 526A for declaratory and injunctive relief and whatever else may be going on. I'm interested in these cases just by happenstance, because that also is an issue that I was going to bring forth and join with another matter that I have before the courts. And so thank you very much for your public service. The lady, she did a fine job making a presentation. There's at least one objection for the record, and I'll just leave myself as the taxpayer. Have a good evening.
Thank you.
Thank you. We have no one else in the queue. Taking the vote. Chair Schmidt.
Aye.
Chair Schmidt, aye. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Member Sugarman.
Aye.
Member Sugarman, aye. 3 ayes. Motion passes. Item number 5. Item number 5. File number 25085. Complaint filed by Michael Turon against the San Francisco Planning Department, Hugo Cabrera, and Chan Sun for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a public records request in a timely and/or complete manner. Section 67.25, by failing to respond in a timely and/or complete manner to an immediate disclosure request. Section 67.26, by failing to keep withholdings to a minimum, and Section 67.27, by failing to provide written justification of withholdings.
Okay, let's check. I think I think Ms. Ford is here for this, and I want to talk about that for a moment before we start. But let's see if I'm sure Mr. Ray is here. Let's see if planning is present.
If there's a representative from the Department of Planning, please raise your hand in the app or press *3. I'll give you a moment. There does not appear to be a representative from the Department of Planning.
No one from planning. I know they submitted a terse document to us. Okay, so, well, planning's not here, but I think we should go ahead anyways. And the first thing I'm going to do is I'm going to ask the petitioner via Petitioner's Council, do you still think that this matter should be brought against Mr. Cabrera? Mr. Cabrera, apparently the reason Mr. Cabrera is in this is because Mr. Cabrera was involved in the claim to the supervisor of records. Is it part of this case that you still seek to assert?
Yes, I think so. You know, it seems like the planning department search missed a lot of records here, and you know, we don't know what else is out there. So for that reason, yes.
Okay, so then we'll include Mr. Cabrera for now, and so with your presentation, I think maybe one thing we'd like to hear is exactly why you've included that person. But that being said, let's go ahead with Mr. Ray, and we'll check again when it's time for planning, but it looks like they do not intend to appear.
Mr. Ray, are you ready for your 3 minutes?
I'm ready. Thank you.
Your time begins now.
Thank you. Again, here on behalf of Mr. Turon, my client filed a sunshine request regarding his property on Folsom Street, specifically requesting text messages from zoning administrator Corey Teague and Mr. Richard Sucre. That was on July 25th, 2025. Eventually on August 12th, 2025, the respondent issued a denial letter saying they have no responsive records to this request. Later on, my client was able to independently obtain text message threads between Supervisor Jackie Fielder and Mr. Rich Sucre from prior to the sunshine request, specifically discussing my client's property on Folsom Street. Also recovered were text messages between Matt Green from the Department of Building Inspection and Zoning Administrator Corey Teague from August 5th, discussing my client's property. Simultaneously, the department claimed no such text messages exist. These messages are, evidence that the planning department failed to conduct an adequate search of the phone records or the text message records from the people who my client sought public records, specifically text messages. They either failed to ask these officials to search their devices or intentionally withheld them. Here we're requesting that the Sunshine Task Force order a new search of planning department devices, including personal devices such as Richard Sucre and Zoning Administrator Corey Teague, which is monitored by a neutral custodian. And with respect to Mr. Cabrera, he is the individual who issued the determination that no records exist, acting as a supervisor of records from the city attorney's office. We're also asserting violations of Sunshine Ordinance 67.21, denoting that the city attorney's office, if the city attorney's office or another legal counsel is a conflict of interest, that person shall not be the one who participates in a determination as to whether or not to withhold records. Likewise, for similar reasons stated in my previous presentation, the respondent failed to produce written justifications for the withholdings besides the blanket assertion of privilege, and also failed to produce the requisite records in their native format or at all.
30 seconds.
Just pointing for your attention, pages 107 and 109. 107 to 109 of the packet include the text messages that my client later uncovered, so that we would direct your attention to that. And with that, we submit.
Thank you.
Thank you.
Let's do one more check for planning department.
If there's a representative from the Department of Planning in the online community, please raise your hand in the app or press *3. We have no hands raised.
Okay. So let's move on to questioning of the parties. Members, if you think it's a mistake to go ahead if we don't have planning, please tell me. But I think we probably can go ahead and do our job on this without planning here.
May I have clarification, please?
Yes.
I wish to hear from the Office of the City Attorney.
Oh, I'm sorry. I'm sorry. What am I? Okay. That was disrespectful. I apologize. Yeah, let's go ahead and hear from the City Attorney's Office.
Are you ready for your
Yeah,
3 minutes?
yeah.
Your time
Thank you.
begins now.
Hi, Jen Court, on behalf of the City Attorney's Office again. This one's a little bit of an odd one for me because I've never had basically a complaint against two departments simultaneously in the same complaint. So I'm not prepared to present anything about planning's response. I don't know the details of that. We honestly thought it was kind of a mistake that he was included, and someone just thought that Mr. Cabrera was like a planning department employee. So he acts on behalf of the city attorney in the function of the supervisor of records. I do believe related to this planning response, there was a petition submitted to the supervisor of records. Supervisor of records responded in a timely fashion and just determined that, the planning department did produce, it sounds like, a couple of additional records that were responsive to the request. And then after that, the supervisor of records finished its investigation and concluded that the planning department hadn't improperly redacted or withheld anything. So I'm not quite sure what else to do with this, or maybe if there's a way to kind of split this complaint or something like that. But yeah, we thought it was a mistake, and we just would request that Mr. Cabrera get dismissed from this complaint.
Understood. I think that we don't expect you to speak for the planning department in any way. We were just I'm trying to just figure out exactly what the claim was against Cabrera. Thank you. Okay, members, any questions? Yes.
This is Member Stein. I could not see, this is a question for the petitioner or the petitioner's representative. I could not see anywhere in this packet examples of records where particular portions were withheld, but I think there were some pages that were just like in extremely tiny type. So can you point me in this packet to, if it does exist, where there might be examples of records that were provided that have withholding that for which no particular justifications were connected to it?
Yeah, you're talking kind of the heart of the matter here. There were text messages from on page 107 and 109. Those weren't produced at all, and no justifications were given for lack of production.
I'm not talking about like records that you didn't receive at all. I'm talking about records where you were given records, but things were withheld within those records, and no justification was given for withholding. Are there any examples of that?
I guess, maybe we were talking about the same thing, but the nature of our complaint is that they didn't produce records and didn't justify the withholdings of those records they didn't produce. So there's not like a redaction or something I can point to.
Okay.
Without a justification, if that answers your question.
Yes, that does. And then I was kind of confused about another aspect of the claims here. It states in your brief that in the August 12th letter from the planning department, they said they had no records to produce. I didn't see that in the August 12th letter. I only saw, and I didn't see that phrase anywhere in the packet. I only saw a letter which talks about, partial production of records. Is there something I'm missing there?
I don't have that letter in front of me, but I suppose that, it's December 16th now, and we haven't received any the text messages from the planning department production. So that's kind of the nature of the dispute.
But planning did produce some records, and they never said they had no records to produce, as far as I can tell. It's just not that statement just doesn't seem to be substantiated in the packet.
Which page of the packet are you on, if you don't mind me asking?
I'm not on, well, I guess I am on a page, maybe. Hold on. Because the letter appears in multiple places, but there's a reference to an August 12th letter. So I guess I'm on page 10. This was a letter sent on August 12th to Michael Turon from planning. And in your brief, you say that they represented that they had no records, but they're talking about partial production and redaction of some of those records, or records that they're not producing due to attorney-client privilege, but they don't say they have no records to produce. So I just wondered if I was missing something.
I have the August 12th email up in front of me. It says what it says, that they did produce some records, but they weren't the text messages that my client asked for, which he later obtained. So that's kind of, that's really the reason why we're here.
Okay, that's all from me.
Go ahead, Member Sugarman.
I'm trying to formulate this. I apologize. I've seen the text messages and that you obtained them from what I recall from the Board of Supervisors. So I just want to clarify, you're seeking those text messages from planning, believing that they had them and did not release them. The same ones and not other ones.
That's incomplete. We don't know what we don't know. So we don't know what other text messages are out there, but the fact that the planning department didn't produce these records
Okay.
in response to a Public Records Act request when they were clearly not subject to any sort of privilege, attorney-client or otherwise. That tells me, and it should tell the task force that they didn't conduct a complete search or a search at all. So I would imagine that there's other text messages out there that would be responsive to the Planning Department Public Records Act requests, in addition to the ones we're able to obtain just by virtue of other department members from other departments being on those text messages.
Okay, thank you. That does clarify my question. That is my. I'm still
For now, okay.
Yeah.
Let me throw out a few. To the petitioner, one of the allegations here, I think, is that there were redactions and they were not keyed. In keying is sort of a term of art for the actual exemption that's being asserted is noted at the redaction. I'll call it that. Is that part of the claim here? Is that they did redactions without properly keying or supplying the exemption at the redaction?
I suppose I'm going to give a similar answer to what I gave before. Withholding the text messages and not providing, quote unquote, keying or asserting any sort of privilege amounts to a blanket withholding. They withheld records. They didn't even tell my client they had them and didn't provide any basis for doing so.
Okay, so there's nothing in the record that was withheld that, well, let's put it this way. I agree with you. You don't know what they didn't give you. So in terms of not keying redactions, you're saying that assertion is being made vis-a-vis the texts that were not received, that would be on personal devices. Am I getting that right now?
You're stating it correctly. Thank you.
Okay, thank you. All right. And a question to the city attorney's office, Ms. Court. Okay, Hugo Cabrera, was Hugo Cabrera the person who signed the letter from the supervisor of records in this case?
I think it would have just been an email, not a
It's an
like a
email.
signed. It either came from him or a paralegal that works with him. But
Okay.
yeah.
Okay.
Yeah.
And Hugo Cabrera is an ACA at the city attorney?
Yeah, he's a deputy city attorney. Yep.
Okay.
Yeah, I don't know. He works on the government team. He does not advise the planning department. So. Yeah.
Got it. Okay. That's all.
Okay,
Yeah.
thanks.
Thank you.
I feel like my mind is endlessly wrapping around the custodian of records issue. Like we've been going over it in different layers past few weeks. So that's what it says in the document is Mr. Cabrera, as the custodian, is responding on behalf of the department. So then it's the same question that comes up. Well, do they have custody of the document though? And they're listed as the custodian. I'm really just thinking aloud. It's not. I'm not making a specific assertion about that. It's just. It's It's okay.
So Hugo Cabrera is not the custodian of records for the planning department. So he would not have, he's just the supervisor of records, and they, the complainant, as the complainant is petitioning you all, petitioned the supervisor of records to take another look at this like response from planning. But Hugo doesn't have any, he is not the custodian. He doesn't have those records. So I just want to make sure. Yeah.
Okay.
Thanks.
So
Sorry.
that's helpful. That does help.
Yeah, I think that the theory would be with Hugo Cabrera, and it's not a meritless theory, is that as the representative of the city attorney's office who was performing the role of supervisor of records under the Sunshine Ordinance, the complaint would be that they violated the ordinance in some way. And so since that's the ordinance, that's our primary, that's most of what we do is sort of enforce the ordinance. We would look into if something was done incorrectly. Now, I'm not saying that we necessarily have jurisdiction to do that or not, et cetera. I think that issues come up before with city attorney's office who performs that role. But I think that's the one assertion that's sort of being made here, although it's not really made clear in the record. I do think one reason I think that we should recommend that we take Hugo Cabrera off is partly because he's an ACA, but I think the only person we can really hold, responsible for anything, it would be the city attorney themselves. That's sort of one way that I think Hugo Cabrera gets out of this. Maybe they, still would want to pursue the city attorney and say that, the supervisor, city attorney failed to perform, and they are asking us whether we want to, find a violation. And it could be that that's something that we send on to the task force, but I think it would have to be the city attorney, not the ACA. Well, if we might as well, if there are further questions, we can certainly ask them. I think one thing we could put into order is, or a recommendation is, planning didn't show up, so that's one thing. There may be, I don't know if delay is a big part of this set of assertions, but there could be delay. I was asking to see if there's any unkeyed redactions, although I don't know if there's any of that per se here. I am interested in two things, though: the metadata and it's unclear to me if planning actually did anything to see what was on people's personal devices. And so I think that we're entitled to at least a confirmation that they told their people to do their own searches on their personal devices. And I think that would be part of what I think we're entitled to here. Member Stein.
Again, I don't know, because I really cannot read this really tiny type where there's like 8 documents to a page or whatever. But I was also interested in the documents not being provided in the original formats in which they were requested. I don't think we actually have any of the documents here, unless these tiny type things are documents that were provided. But I think, for the petitioner, it would be very helpful if you want to say that, things weren't provided in the correct format, or metadata was not there, that we see what that production looked like, or maybe not all of the production, but at least a sample of the production where we could see where that's happening. And the same thing with redactions, which maybe they're just not using the correct terms because we don't have anything that really shows us there were particular provided documents and the examples of, chunks being redacted and no justification given. But if that's going to be a claim, we should see that production so that we have, something specific to kind of point to and evidence of what it is that, you're saying. So I do have those couple of issues, right? Like that some texts weren't provided that would have fallen under this, that planning didn't show up, that things weren't provided in the format requested, and that, metadata was not included when specifically requested. And yeah, planning not sending a representative. So.
I personally find the the text message issue persuasive. To me, it would. I think it's highly plausible that you might not find more text messages, but that they still should have been provided by planning and not from the supervisors.
Yeah. And I know that, the petitioner asks that we order that they inspect, like that planning to inspect their devices. I wouldn't go that far because I don't think that the law really does go to that extent, but you can tell the people that they're obligated to inspect their own devices to see what's responsive. And I think that's pretty clear in the law. And that's what I think our direction to them would be.
I also would just add that there are claims in here related to failure to engage in proper extensions, enrolling production, assign a neutral custodian, or provide records logs with names of reviewers. And I didn't find those compelling. And I don't think they really come from a clear reading of the Sunshine Ordinance and what we actually have jurisdiction over. So I would want to send some signal to the full task force that those are claims that we don't think we need to look at. Because there's a lot being claimed here, and I think some of it, holds water, and some of it doesn't seem to based on what we can do.
Maybe this would not be our typical thing that we do here, but maybe we give a list of recommended possible violations, and then maybe recommended non-violations.
Right.
Yeah, it's just a recommendation, so they can ignore it. It's going to go, I assume it's going to go to the full task force. So we're just guiding based on what we thought.
Yeah, I think so. I think that, we'll say, there's one recommended violation, for example, is that planning didn't appear here. And I think that we all agree on metadata. We agree on searching for the texts and text-like creatures, signals, that kind of thing.
Incomplete production.
Incomplete production, yeah.
But not a timeliness violation. And I agree with that with Member Stein.
Okay. So even though it's all about me, I'll let one of you make the motion this time.
Okay, I will move that these are public records under our jurisdiction and that we forward this case to the task force to consider, or with a recommendation, just to consider violations around withholding metadata, not providing records in the original formats requested, the possibility that see how to put this. The fact that planning did not send a representative. And that we believe there were some records that should have been produced but weren't from people's personal devices. However, claims related to the failure to engage in proper extensions and rolling production, to assign a neutral custodian as supervisor of records, or to provide record logs.
I'm sorry, just a moment. That some records from personal devices were not produced. And what followed that? Claims
The,
about production.
Claims related to proper extensions, rolling productions, to assign a neutral custodian for records or record logs.
Just a moment.
Wait, but are you saying the planning did not send a representative?
I'm just repeating what you said.
No, I think she missed, I think Ms. Peterson missed the part about that planning did not send representative. Do you have that there?
I have that.
Oh, okay,
And
sorry.
that some records from personal devices were not produced. And then the claims about production, did I,
Claims related to proper extensions.
just a moment.
Are related to the failure to engage in proper extensions.
Just a moment. That claims related to proper production.
To
Claims related to the failure
engage.
to engage in proper extensions and rolling production, to assign a neutral custodian as the supervisor of records,
Just a moment. A neutral party to review production of records.
to assign a neutral custodian as supervisor of records,
Mhm.
or to provide record logs with the names of reviewers are not compelling.
Moved by Chair Stein to find that the task force has jurisdiction, that the requested records are public, and forward the matter to the task force with a recommendation to consider violations around withholding metadata, not providing records in the original format requested, that the fact that planning did not send a representative, that some records from personal devices were not produced, that claims were related to the failure to engage in proper extensions and rolling production, that there was a failure to engage, to provide a neutral custodian as supervisor of records, or to provide records laws with the names of reviewers are not compelling. Let's
Yeah,
see here.
and that's a new sentence, right? So claims related to, that's all a separate sentence.
Okay. Is there a second?
I second.
Seconded by Member Sugarman. Taking public comment on the motion. If you are in the room, please approach the podium. If you're online, please raise your hand in the app or press *3. We have no one at the podium, no hands raised.
I'm going to have another motion in a minute. Go ahead. Go ahead.
Taking the vote. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. 3 ayes, motion passes.
I have another motion on this same matter. I move to recommend that Hugo Cabrera be dismissed as, instead of as, for the reason that there are no cognizable claims against him, since only the city attorney himself is legally the supervisor of records.
I have a question before we proceed with that.
Yeah.
Is that something that can happen on consent, or just can we remove them for, like, if it gets forwarded to the full board, as their name no longer appears on the?
I have no problem putting on consent. Although I guess what that would do is we'd kind of be splitting two parts of the same matter. But, yeah, it could go on consent. Yes.
Did we not recently have a case where we determined that we don't really have jurisdiction over the supervisor of records? Thought we did. I haven't.
I don't know which way it went. I know that the question has come up. I forget what the vote would have been on that, but yeah, it did.
I would have to find it to verify that. Yeah, 'cause I don't remember any real mechanism by which we would be able to, hold them accountable for a decision. They're just a separate place people can go to get that determination of.
It might have been that I made a motion and that was one of my losing motions from the other side. But since I lost, I forgot what it was, and it has come up, and I think it's a valid question. I don't know if it's necessarily the question we needed to even get to here.
No, I just thought to me, it makes it easier to put it on the consent calendar and just say this is not a.
Yeah. I mean, we could split it off and say that on this motion, we put it on the consent calendar, and that's fine with me. So instead of recommending, well, we go ahead with the recommendation and we add this will be placed on the consent calendar.
Is there a second?
I second.
Seconded by Member Sugarman. Moved by Chair Schmidt, seconded by Member Sugarman to dismiss Hugo Cabrera for the reason that there are no cognizable claims against him, since only the city attorney is legally the supervisor of records, and to forward the matter to the consent agenda. Taking public comment. If you're in the room, please approach the podium. If you're online, please raise your hand in the app or press *3. We have no one in the queue. Taking the vote, Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. 3 ayes, motion passes.
Okay. All right. Thank you to the parties. Let's do one before we take a break. And this is the Petrellis in the mayor's office matter.
Item number 9, file number 25102. Complaint filed by Michael Petrellis against Mayor Daniel Laurie and the Office of the Mayor for allegedly violating Administrative Code Sunshine Ordinance, Section 67.25, by failing to respond to an immediate disclosure request in a timely and/or complete manner. Mr. Darmali, promoting you to panelist. Mr. Petrellis, if you are in the online community, and I have identified you, one moment, please. Mr. Petrellis, confirming that it is indeed you that raised your hand. Mr. Petrellis, I'm going to unmute you. Is this Mr. Petrellis?
Hello, this is Michael Petrellis calling in. I hope you hear me.
Yes, we can hear you. Thank you. Parties are present.
Okay, when you're ready, we'll hear first from petitioner.
Mr. Petrellis, are you ready for your 3 minutes?
Yes, I am.
Your time begins now.
Hello, Sunshine Ordinance Task Force members. This complaint, I believe you have jurisdiction over this. I believe that the mayor's office is creating telephone logs and logs of any Zoom calls that the mayor has. I made a request to the mayor for, I believe it was 5 weeks worth of phone logs, Zoom logs, I think also transcripts of his phone conversations. And this stemmed from a phone call the mayor had with President Trump, and then follow-up phone calls with Kristi Noem, and then Pam Bondi, the Attorney General. And it's my contention that the mayor of San Francisco is creating such logs. He is documenting, he is memorializing calls with federal officials in particular, and what is said during the calls. Here's a hypothetical. I think if during the call with Trump, he said something such as, well, you know, I'm going to resign. I'd love it if he did say something like that. But if he did, it would be incumbent upon the San Francisco mayor to have a recording of whatever Trump said, especially if he said he was going to resign. These are the reasons why I filed the complaint with the task force, because I believe the records are being created, they are maintained, and that the mayor is not right in withholding these documents from me. And I'm really looking forward to what Dexter has to say in response. Thank you.
Thank
All
you.
right, thank you.
Mr. Darmali, are you ready for your 3 minutes?
Yes, I am.
Your time begins now.
Good evening, everyone. So this complaint was with Mr. Petrellis was closed on October 30th. No documents were produced, and there are no documents responsive to this request that are being withheld. The first part of this complaint was Mr. Petrellis saying that an IDR was violated, and this request should have been treated as an IDR. It is, let me just read the request. Is a copy of telephonic logs, including but not limited to all cell phone, Zoom, or FaceTime or other video and audio conferencing, the date, length, and topics of all calls, either initiated by you, Mayor Lurie, or your staff at the request of other parties and individuals from the period between September 1st through October 27th. So this request, how it was read, was that they were looking for logs throughout the whole office, and it takes longer than one business day to search for what this request was asking for from an entire department. With that, even though our office responded to Mr. Petrellis saying this would not be treated as an IDR, we knew that we wanted to get a response to Mr. Petrellis sooner than the 10 days. So we worked diligently and responded, I believe, within 3 days of receiving this. We responded under the 10-day deadline, so far sooner than the 10-day Park sooner than the 10-day deadline. Mr. Petrellis also claims that documents do exist simply because we asked for clarification on the request, but this is not what that means by any means. We have no responsive documents for the request. We were asking for clarification because we knew the requester wanted documents sooner than what the 10 days would have allowed, since we weren't able to do an IDR. So we were asking for clarification because maybe that could have moved the process along faster. But we received no clarification, but still persisted on completing this request as soon as possible. So given that we have no responsive documents and this request is closed, I ask that you close this request accordingly. Thank you.
Thank you.
Thank you.
Okay, now, any questions? Member Stein?
Okay, I have one question for the petitioner first. Why do you believe that telephone logs and Zoom call logs exist?
I believe that in this day and age, these records are created for many purposes, especially by the chief executive of San Francisco, that he needs to document in case there are legal challenges in the future to what he claims was said in a phone call, or if he claims a number of phone calls with federal officials, and the public would like to know, well, how many calls did you have with the federal officials? I really do think it is standard operating practice for top elected officials, mayors in particular, and this mayor, who is quite tech savvy, that he is documenting who he speaks with in his capacity as mayor, and that he is memorializing his conversations. Anytime the mayor has a photo op, there is a social media operation that gears up to put out the mayor's texts and what he said, quotes of what he said, along with videos and audios of what the mayor has said about, for example, the fire department now has equipment that doesn't cause cancer. I just do not believe that the mayor isn't keeping track of who he is speaking with on the telephone in his duties as mayor.
Okay, thank you. And then I have a couple questions for Mr. Darmali. Do any phone or video call records exist, either on their own as logs or in any other form?
The logs and the types of logs that this request is asking for, we do not have.
Okay, the types of logs this request is asking for, but are there records in some other form that would indicate a record of calls, whether video or telephonic?
That would be on the Prop G calendar, as all elected officials in the city are required to have. And Mr. Petrellis asks for the Prop G calendar very frequently, and he has that.
Okay. And then this might be kind of, you might have already answered this, but if Mr. Petrellis had provided you with search terms or otherwise narrowed his request, do you believe you would have been able to find some responsive documents?
I don't believe so, because we searched everything and we found no responsive records for what this request was asking for.
Okay, although you did say that Prop G would have records related to this, but had you already given him the Prop G records, or you just didn't include it because it wasn't technically a telephone log or a video conference log?
Look, I don't understand the Prop G to be a telephone or video conference log.
Okay, all right, thank you. That's all from me.
I have a question to the respondent. The calls to federal officials, what type of phone does the mayor use to make those calls?
I do not know, as I was not there.
Okay. Are there any landlines in the mayor's office?
In the entire
In the
department?
at the mayor's desk, let's say.
I'm not aware of any landlines. It's possible, but it's nothing that I'm aware of.
Okay. Does the mayor have a city issued cell phone?
I do not know that answer, but I can tell you that whenever documents are sunshined and requested for the mayor, I explain that any document on a city or personal device that is pertaining to city business is sunshineable.
Okay. And when the mayor communicated with federal officials, was that on just a regular telephone line, or was it any kind of protection such as encryption or anything that would allow or it would prevent outside parties from listening in?
I do not know the answer to that question, as I wasn't there for those phone calls.
Okay. Thank you. I got nothing further.
I just have one more question. Can you, Mr. Damali, just give us some details about how a search was performed?
Yes. So this request asked for telephone logs, cell phone, Zoom, FaceTime with the dates, times, lengths, and topics of conversations, or what these logs would have had. And it was me going, because I knew the timeline for this, we wanted to get it closer to an IDR, even if we couldn't fully treat it as an IDR, knowing like the real limitations on it. So I spoke to the staff about, hey, this is what this request is asking, do we have it? And our team did not have the documents this request is asking for.
Do you know how they searched for those documents?
Was not the one collecting everybody's device, but I was explaining the process. So I don't think, given like the size of our department, I don't think I can give you one answer.
So you explained it to the people that were connected to the request to perform a search on their own devices or their own accounts related to the logs or something that would resemble a log that resembled the request that Mr. Matralis made. Is that correct?
So I have explained to my team, when this type of request comes through, this is like what the type of document you need to be looking for is.
And what type of document were they looking for? Just a log?
Logs including but not limited to all cell phones, Zoom or FaceTime, or other video and audio conferencing, the date, length, and topics of all calls.
Oh, okay, so they could have extracted this. These were the date. Well, I guess, but they couldn't really extract it if they didn't have a log, because that's a new record. But okay.
Okay, we may have more questions, but we are past our question period. So let's figure out what to do with this in terms of sending it on to the full task force. Again, to the parties, we don't make any final decisions here. What are your thoughts?
Okay, my initial question to the committee is what happens when, because I do believe that the request made, I will be honest, was overbroad, first of all, but also could not have been treated as an IDR. So what happens if it's not an IDR? I know that there's, we've discussed in the past rolling production, but like if it's not an IDR, is it within an office to say, as this office did, this is not an IDR, therefore we dismiss this as a non-IDR? So is that possible?
Or are you saying that do they have the
right
option to make that call and say, make the call within their office? Okay, we are not going to treat this as an IDR. We're going to treat it as a regular.
No, but that's not what they did, though. They said, this is not an IDR, therefore we don't have documents for you.
Is that is that what they did? That's
what I saw in the packet.
Okay. Since your request doesn't qualify as IDR, we don't have to respond to your request. It sounds, but we've been talking about.
Yes, please clarify it.
Yeah, we've been talking about that they did search.
It's not, yes. And I thought I want to also add, I do want to hear the clarification from the respondent. I thought your questions were very helpful, but that is what I read. Was that it wasn't an IDR. And therefore we don't have responsive documents. Sorry, hold on a moment.
Regular request.
Okay. Please, I'd like to hear from the respondent.
We wrote on October 29th that this is not an IDR and will be treated as it is not simple, routine, or otherwise readily answerable and will be treated as a standard request. And then on October 30th, that's it. Then October 30th, we respond to the IDR and close the request. Or we respond to the IDR that's being treated as a standard request and close it. It was not in the same message. The mayor's office saying this is not, that we did not say in one message, your request is not an IDR and we have no documents. Those were separate messages on separate days.
Thank you.
So you're confirming that you did do a document search here. You didn't, it sounds to me like you didn't just reject this out of hand since it wasn't per se, it didn't qualify as an IDR. You did a search.
Yes, there was a search.
Got it. I think that answers that. Thank you. I think this may be one of those, oughta, shoulda, have, but don't, or they apparently don't have telephone logs, don't keep telephone logs, and therefore they have nothing that they've got to produce.
So I have to there were two things going on. That does answer part of one of my questions. Thank you again to the respondent for the clarification. It still doesn't necessarily answer the question if you can convert it to a standard request. It does say that the respondent was trying to assist the petitioner and didn't just dismiss it immediately. However, the other thing that I wanted to add is even though the request is overbroad, I don't believe that there aren't logs. I mean, certainly I believe there in the context of what you describe as a log, like there's like, because you're asking it for like of all the staff, right? There's not like I don't think that there's a combined log of their communications that exists for someone to request and then for this person to have. Do I think, however, like if I opened my phone right now, it would tell you everyone that I have called until about like 2022. Like it would go back several years. I don't know what their housekeeping policies are for everyone's personal device. But the idea that there are no logs between the mayor's office and staff, I don't buy that. But I do think that like looking at the requests, we've seen this. I do think a lot about the Mayor Breed case with but that request was very specific. It was, I would like to see the latest message on city business between this time.
Yeah.
Whereas this request was, I would like to see everything that's happening between the mayor's office and staff between this time. And in that sense, it was so overbroad that it certainly was never going to be an IDR. And I don't know like how the office would have like produced potentially that many logs. However, I do think that there would be logs. And from what the respondent said, it felt like the respondent said, I have told the staff how these requests must be handled. And I know the respondent's listening, but I didn't hear, I told them specifically about this request. It wasn't like a marching order, like, well, this petitioner requested this, please go look for these logs. It was more like, this request came in, let me know what you have. And we've talked about how these requests come in before. So I personally have some questions about like that part of the procedure. Even though I honestly completely understand the mayor's office response. Like it seems like it's a bigger task to have to come with all that information. That's a lot of information to ask for. I'm sorry if that's a little bit complicated of an answer.
Well, I think it's also kind of confounded by the fact that there aren't deliberate logs being kept that have the information the petitioner is asking for. I mean, I'm just looking at calls I make from my cell phone, how it's logged, for instance. There's no time on it. I don't know how long those calls were. The only thing that's on it is a phone number, which I think could be, potentially a privacy invasion. I don't know, maybe not. And then certainly not the content or the topic that was discussed is not there. So, I mean, there are things that would log actual numbers called in or out, but it's not a log of the type that this petitioner is talking about. So it would either, they would have to construct records to do this. And yeah, obviously, we can't really say it shouldn't happen because it's so cumbersome, but it would be hugely cumbersome for everybody to kind of search through and try to figure out, okay, these were personal calls, these were actually city business. If there was a landline, I think it's easy enough to show the number of calls or something, and the dates might be there. But again, and maybe the time would be there as well, but the topics wouldn't be there. So in a way, the way that this is written, you can see why they would also feel like there's not really something that is going to be responsive to this particular request.
Yeah, the term was used, telephone logs. And so I agree with everything said here. That's the term we're working with. And it's somewhat of a, round peg in a square hole or square peg in a round hole. Like, that's maybe a term that was very understandable in 40 years ago. But now, what does a telephone log look like? Nobody would keep the same kind of telephone log like what people would have done 40 years ago. And like you both said, the only thing that in day-to-day life that looks like a telephone log is just that list of phone numbers that is on a cell phone. of the people that you've spoken to over the last 3 years or whatever. And I don't know if that's a telephone log or not. And, it's possible that, say the mayor's got a cell phone and the cell phone tells you all the calls that were made. Maybe that could be construed to be a telephone log, and maybe it is a public record. You could take out any personal calls.
Mm-hmm.
Possibly. I don't know the answer to that question. I think that maybe that was not considered to be a telephone log, which, by the mayor's office here, which it makes sense, some sense. But if we, broadly construe the term, maybe that would be a telephone log. I don't know.
I would consider the date and length, because it says date, length, and topic of all calls. I would consider the date and length. If I think that I would be able to look into my phone, as Member Stein has said that she can find the date. I can probably find the date and the length of each call.
Yeah.
I will not. I don't think that it's a reasonable request to say that I should remember the topic of each phone call that I had, even if it's city related. I'm not sure I would remember that. If I did not, and if I was, I am in a city position, but if I was in one, in the mayor's office, I also don't think that I would make a record of every single phone call, like what the topic was about, to have to recall that for public record. However, I still think that the date and length of a phone call, like if you have in your phone log and it says that I Saul Sugarman called the planning department, that's going to be in my phone. So
It's also on your bill.
Yeah.
But also, I will just say that I have calls in my log, and I don't know, just by looking at the number, whether it was a personal call, a business call. I don't know if I haven't recorded, who that call was to. So it seems like almost impossible to reconstruct which of these, just from the phone records themselves, which of these calls were city business, which were personal, which were calling someone to make a haircut appointment. I mean, who knows?
I do think the request lacks a bit of specificity in that way. But I still think that if you're one city department and you're calling another city department on your cell phone, then more likely than not, it was a business related call. Like you're not asking them all to lunch. I
know, but I guess I'm just saying someone might say you need to call planning unless you pre-programmed in your phone that this is planning, even on AT&T records, it's just the number that's going to come up. It's not going to say this was planning's number.
Yeah. Technically, it is if there's some notation that says that a call was made and it's on city business, then it seems like even just the record of the phone number is technically a record of city business being conducted on that call, in the case where it's obvious that it was city business. And so under City of San Jose, it's unclear what the City of San Jose case actually requires, because a lot of what that case does is it tells cities that they should implement a system whereby people are asked to find all their public business phone calls in response to any kind of a request. But I don't know if we can say that the mayor's office is required to, find all those records of just phone numbers that were called on people's personal cell phones. But those are public records, technically. yeah, I think they're public records. I don't know, if that's something that falls within the request that was made here by Mr. Petrellis. But in a case where it's unclear, we have to kind of construe things broadly. And so maybe just based on our conversation we're having here, we can't make a recommendation and we don't have the feeling that this is consent. And so maybe we just pass this one along and just say nothing. Do you have, what do you think? You go ahead if you think it's something different.
Deciding. I kind of think there was a violation, but I also think that the request needs more specificity as well.
And the respondent asked for more specificity
And
and
the-
did not get it.
Mhm.
So where does that then leave things? I mean, asking for more specificity would seem to, indicate a desire to help.
To work, yeah. Mhm. Oh.
I mean, I just try to imagine like a scenario in which records would be provided. I mean, I guess you could say that, well, if there is a city-sponsored phone that presumably only business is done on that phone, and those phone
Okay, yeah.
records can be provided, they're not really the log that's asked for here.
Yeah, I kind of go back to, again, the Mayor Breed case with the texting. To me, that's like saying, please look for any messages related to city business, and they come back and say there are none. Please look into your phone for logs for any city business. There are no responsive records. That does not. But he didn't ask for anything like to city business, which would be in the realm of public record. That's what I'm saying about the lack of specificity. But what I feel like the response from the office was, we don't have logs like that. And that's what I'm saying is I think that's like that to me. It's like saying we don't do city business on our phones, is what that sounds like. So that's where, like, to me, the violation is. It's more like it's exactly what you're saying. It's a lack of assistance, even though they asked for clarification. And I'm not saying that I feel, that's why I say I'm thinking about it, because I'm not 100% on that. I be persuaded. It just feels like,
Yeah. Well, I don't know if we would even come to a consensus on anything here today.
okay.
I mean, I'm kind of with you on this in terms of like, it looks like maybe they didn't do enough, but the use of the word telephone log, someone could say, well, we don't keep telephone logs. And we're kind of saying, well, maybe that's not everything you need to do, partly because you do have a log on any kind of cell phone. And even if you may have a city issued cell phone, or as I understand it, a personal cell phone where you make that call to, Christy Nome or whoever, and it's listed on the phone. That's a public record. And so maybe, that maybe that should have been provided into Mr. Petrellis in response to his request for telephone logs. I think that's arguable.
Okay.
I don't know which way I'd vote on that one myself as we sit here today.
I support moving this to the full board. If you don't want to have a recommendation at all on it, that's okay with me too.
Is that a motion?
Member Stein,
Yes.
if you have,
I guess it has to go go to the full board, but I feel like it was almost like an impossible request to fulfill.
And I agree with
And
that.
I think they did try to figure out like, well, what's really relevant here, like
Okay.
what do we see, and that, you know, the idea that they're going to go through and try to figure out from numbers that are there, what was city business, what wasn't city business. I mean, it just seems impossible. And it's never going to be a record of like what was discussed there if they're just looking at telephone records. I mean,
And
for
I
me, it just,
agree with that.
I just feel like the request is so
I agree with all of that.
conceived.
Okay.
So but you know, I don't know what we're supposed to do with it.
I agree with all that too. I feel like I would like to see this, like, it's not the bellwether case. It would be better if it had more specificity. Like but I still think that it's,
I mean, I
anyway.
guess it's so unspecific for me. It does kind of become a document that doesn't exist. And that's you know, I understand why the mayor's office dealt with it the way they did. But yeah, we can send it to the full task force. I don't know what else we can do with it.
Okay. I'll move that we send this for decision for the full task force. There are, it involves public documents. The task force does have jurisdiction. We make no recommendations on the request for a finding of a violation of 6725 or 6721.
Is there a second?
I'll second it.
Wait. I have a question first. Can we ask for more specificity in this motion?
I mean, I feel like this is about this request.
Yeah, okay.
If I were the petitioner, I would go and ask for something more specific that's obtainable, but that's not this request.
Okay. Do you want a second, or I can also?
I seconded it.
Okay.
Okay. Taking public comment. If you're in the room, please approach the podium. If you're online, please raise your hand in the app or press *3. We have no one in the queue. Taking the vote. Chair Schmidt.
Aye.
Chair Schmidt, aye. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Member Sugarman.
Aye.
Member Sugarman, aye. 3 ayes. Motion passes.
Okay. There we go. Thank you to the parties.
Thank you, parties.
Thank you.
Let's take a break till 8:10.
The committee is in recess starting at 8 o'clock. Microphones are off.
Bye.
Microphones are on. The committee is back in session at 8:11 p.m. All committee members are present. Item number 7. Item number 7, file number 25099, complaint filed by Grant Review at proton.me against the Department of Public Works for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a public records request in a timely and/or complete manner.
All right, let's see who's here on this one.
Petitioner has been added as a panelist. Do we have a representative from the Department of Public Works present? If so, please raise your hand in the app or press *3. One moment, please. Let me check and see if I had a response from Public Works. One moment.
David should be on there. David Steinberg.
Yes.
He'll be on there. I'm Chris. I'm just the staff.
Yeah. I know.
Oh, are you here on this matter? Okay, okay. All right.
Hello, is this Mr. Steinberg?
It is. Thank you.
One moment, please. Promoting you to panelist. Mr. Steinberg and petitioner are panelists.
Okay, so petitioner first, when the timer is ready.
Petitioner, you will have 3 minutes. I will give you a 30-second heads up. Are you ready to speak?
Yes.
Your time begins now.
Good evening. This case concerns the department's failure to produce the delayed replacement tree report, a mandatory public record required by the city's administrative code. I'm asking for a finding of willful violation and official misconduct because the evidence in your packet proves the custodian knowingly misled this body. On November 18th, Mr. Steinberg submitted a sworn response stating no such records exist. To excuse his failure, he claimed the law requiring this report was relatively new. That excuse was false, and he knew it. Please look at the item 7D in your packet. This is a public records response from June 2023, 29 months ago. In it, Mr. Steinberg admitted in writing that he knew this report was required. He knew about the law for years, he failed to comply, and then he misled this committee by calling the law new to cover it up. Furthermore, despite claiming on November 18th that no records exist, the very next day, after I filed this complaint, the department released a spreadsheet containing the exact data I requested, dating back to 2023. This proves the records existed, were in their possession, and were withheld until you got involved. Mr. Steinberg may argue today that because the report wasn't finalized, he could deny its existence, but Section 67.24A makes drafts public. He didn't say we have a draft. He said no records exist, while sitting on years of data. I ask you to refer this to the full task force with a finding of official misconduct due to this custodian's willful misrepresentation of facts.
Thank you.
Thank you. Mr. Steinberg, are you ready for your 3 minutes?
I am.
Your time begins now.
Hi, good evening, Chair Schmidt, members Stein and Sugarman. My name is David Steinberg. I'm custodian of records for San Francisco Public Works. So the very simple question before this committee is whether the department had a copy of the requested records, and if so, whether it produced it in a timely manner. The answer to the first question is no, and the second question is therefore moot. Public Works has consistently maintained that no delayed replacement tree report was ever produced. Early attempts were made to try to come up with a reasonable methodology for creating a report, but that was never successful. On November 25th, I released to the requester several documents, including a 13-page email chain from 2022 and 2023, in which Buff staff clearly discussed the problems trying to create a delayed replacement tree report, which helps explain why none was ever created. You can read a copy of that email chain in your packet, which is listed as item 7C PDF. All the other issues raised by the complainant are really irrelevant to the case. I mean, I didn't make a sworn statement. Of course, everything that I send to the committee I will maintain is truthful, but that was never under oath. And quite honestly, the fact that a previous requester had asked for the same thing, the requester, he found it. I had no recollection of it, but then I deal with 12 to 1,300 requests a year. So, if we want to go down that rabbit hole and know more about the reports and stuff, Public Works Urban Forester Chris Buck is at your hearing now, and he can answer questions as a subject matter expert. Thank you.
Thank you.
All right, now we may have questions. Member Stein.
Okay. So I wondered, this is a question for Mr. Steinberg. In the end, it seems that there were some draft reports released or a mapping survey, various documents that had the words delayed replacement tree report in them, even if they weren't technically officially a report. Can you tell me more about when and how you found these documents in the search process?
Sure. So, and as I wrote in the note to the requester, I close out. Well, let me step back. I talked to our buff staff and said, here's this thing that was requested. What can you tell me? And Chris Buck said, we've never been able to create one of these reports. We tried. We didn't have the technology. It's something we really want to do, but we've never done it. So I relied on his word that was the case. And then, so I closed out the request. I think it was like 5:30 or 6 o'clock in the evening. And a few hours later, just after midnight, the complaint was filed. So I got a copy the next day. So I went back and I talked to Chris, and he said, let me go back. Well, he came back to me and said, I wanted to refresh my memory on how far we actually got in trying to create these reports, because I know we were trying to do that. So he went back and he went through some old files, and he produced the things which I released to the requester and copied the task force on. A couple of them say draft, a couple of them, they say different things. But again, I think the key one is if you look at that 13-page email transcript, you can see that they were clearly, were never representing that what they came up with was an actual tree, the actual report that was required. They just said they didn't have the ability to do it. They needed to talk to IT and figure out how they can pull data from different databases and what would qualify and what wouldn't and how they do it. And they spent some time on it. And then the woman who was heading it up left the department. And so that's kind of where it sat until this request came in. Again, Chris can speak to it better than I, but even when I sent those documents to the requester, I basically said, these aren't responsive to your request, but I think they are related to what you asked for. I think you'll find them useful. So that's why we released those documents. The request wasn't for any documents related to a tree replacement request, which would include drafts and things like that. It was clearly asking for a completed tree replacement report, most recent tree replacement report, and that has never been completed and never been submitted or filed.
Okay, thank you. That's all from me.
Sure.
This is Chair Schmidt. I'm going to ask a question to Mr. Steinberg. The documents that were later produced, not the emails, but these sort of they're rough material charts, and they may have been something that was developed in order to possibly at some point, actually have this report and to create it. But the documents, the pages that you produced, did those contain data that was sort of verified to be correct in the way that you would verify information if and when you were to put out a final report as the kind of report that we're talking about here that was requested? Is there possible that there were mistakes that hadn't been checked before this report were gotten out, and these were just sort of like rough numbers, anything like that? Could you describe what the data was like, the state of the data here?
I'm not the subject matter expert, but Chris Buck, who is there, is. So I would suggest if he can speak to that. He's the one who found the old files, and he was involved he's in the email chains and was involved in the production.
Okay, he is here, and I was trying to figure out a way to get him involved. Here you go. Did my question make any sense?
It did. Thank you, Chris Buck with Public Works, Bureau of Urban Forestry. Urban forester, been with the city 20 years, and 5 years before that with Friends the Urban Forest as their education coordinator, a nonprofit tree advocacy group. You probably don't recognize me because for 25 years, I've done nothing but try to help and serve the public and be inclusive and more expansive in responding to records requests. So it's probably a good thing that we're not on a first name basis. And I just wanted to slip that in there. And I also wanted to show you that I'm here because I really respect this body and the work that you do. So I understood your question. And the question was, is it, what was in some of these reports? Were they final? Were there rough numbers? Were there potentially corrections to be made? And absolutely, the parts of the delayed replacement tree report, it's great that the petitioner says, hey, this document looks like it's got a bunch of data on it. We can produce all kinds of data. But the delayed replacement tree report also includes details on when we anticipate, planting trees that have not been planted within 120 days, and the reasons why we have not planted them yet. And so it really, these were in 2022, in 2023, 2024, we're trying to make strides on how we could do this. Feels like splitting the atom. And we ultimately failed at that. Separate conversation about how we still wish to do that. And we anticipated the petitioner would like to see that information. But ultimately, when the request came to us, the answer is no. That report, as required, doesn't exist in a way that we would share it publicly. Publicly meaning we've summited the mountain.
I get it. Yeah. So now the word report in sort of like old-fashioned ways, you could think of something like an annual report or a quarterly report, et cetera. Is that what this report, if it did exist, would be? Would it look like a quarterly or an annual report? Or is this like a report that sort of is continually updated because you're using it in your daily work?
Correct. The ideal version of this is going to be a running report that's updating, weekly or monthly. Weekly would be aspirational, but perhaps at least monthly. So it would be something that would be getting updated monthly. It wouldn't be a fixed in time document. So one of the documents we provided had a date of April of 2024, yet the delayed replacement tree report asks for trees removed in the last 120 days of today and the status of those. So the closest dated item that we have, and had is April 2024. But again, it doesn't have several columns of information such as how long there's missing information. It's not just sitting there like, hey, why didn't we produce this?
So it's conceivably, say you were to have that report at this time in late 2025, it sounds like the trees that would be on the report would be completely different than what that report would have looked like a year ago. It's a turnover type of thing, right?
Correct. It would need vast updating. It absolutely, it would need 1.5 years of data added to it at a minimum.
Okay.
Yeah.
Okay. Thank you.
Sure. Thank you.
Okay, members, we may not have any more questions. We may have questions, somewhat of a straightforward thing here. Question? Oh, I thought I saw a hand raised. Yeah, it was. Okay. What do you think we ought to do with this? I tend to not. It seems to me that the documents that were provided later on were not necessarily done as like, oh, I should have produced this to you, the first time around kind of thing. I think they were like, well, here's some stuff that's kind of what you're looking for. But as we answered earlier, no, that report, it just doesn't exist. It's not a thing that has been developed. It doesn't exist. And so I don't know if I would see any violation unless there's something over the timing, the 10 days, the 14 days, et cetera, which, I don't know if I necessarily see that they did anything wrong with that. Although it seems like they could have probably turned this around pretty quick and just said, within say 5 or 10 days. No, that's not a thing. But maybe it takes a while to get a report back as to whether that report actually exists. I don't know. So maybe there's a timing violation to me, but I don't know if I really see, and I could even see we could do it as a recommendation or a consent as to no violation other than the timing. But I'm pretty open on this.
I don't feel informed enough about a specific item that perhaps came up that I've missed about the legislation around this, the requirement of this report.
Yeah.
I feel like even sometimes things are required, or sometimes information is supposed to be collected in particular ways, and people aren't doing it for whatever reason. And that, we've seen that a lot, I guess. And I feel like this is another case of that. And, sometimes the information you get is that there is no information and this report isn't happening, even though it's supposed to happen.
Is that a violation?
I don't think it's a violation from our perspective. I don't think we can police, are they collecting the information they're supposed to collect or responding to the laws or policies that are outside of the ordinance about what is supposed to be happening. I guess my one thing here is, I wish that they had found these documents without the time delay and just said, we don't have that, but here's these, and it's all within the time frame. I don't know if the petitioner would still feel like this is that they would want to bring forward the complaint. They do seem like many petitioners, incredulous when materials are not there that are mandated somehow in other aspects of the code or law, but I don't think that is under our that we can do anything about that. We can only look at, if the records were there, did they provide them? I wish these records had been provided earlier, because it does seem like it's something that relates directly to the request, even though it's not the official report.
Yeah, that's the
But-
part that kind of I'm also hung up on, is that it seems as though public records existed, but also the request was very specifically looking for a report. And the one other business in it where he discussed a draft. It's one thing that the one journalistic expertise I'll bring tonight is that we do consider everything published when it's sent. So I don't mean the draft. I mean, like, once the draft becomes an email, for example, or something else, like it's on the internet, then it's considered published at that point. So a draft would not be something that I would consider like immediately anyway. I would not consider it a specifically like a public record yet.
Yeah.
I also do believe that they looked at it, the request, and said, we haven't done this report.
Yeah.
And then kind of had the second thought after closing the request. They're like, oh, well, maybe there is something else that might be there, even though it's not the report.
Right. Well, they were helpful.
Yeah, yeah.
I do think that it's important that we be clear that, yeah, we can't enforce those laws that say they are supposed to have a report. That's outside of what we do. All we can do is deal with the records request here and whether the response, is satisfied the Sunshine Ordinance or state law. If they don't, if they're not in compliance with the law about that report, that's just not something that we would really consider. We don't try to, decide, well, do they have justification for that, et cetera, et cetera. That's outside our scope. Just to, put that, I think that's pretty much clear to everyone here. Yeah.
I guess in this case, I'm maybe leaning towards no violation, because I think they got back in the time required.
Microphone.
So I'm kind of leaning towards no violation, because I think they did respond in the time required, that there was no report. I feel like what they came up with later was just trying to be helpful over and above, what was actually, what documents actually existed that would have been directly responsive to the petitioner's request. So I guess that's kind of where I'm leaning. I don't know if I should make a motion or not, or if people are definitely not leaning in that direction, I won't.
I would probably be, I want to hear from Member Sugarman on that, but I would probably be amenable on that.
No, I'm on the same page. I was mostly wondering in a timeliness sense, that's the only thing. Because I agree with what everyone else said about just basically what you said about the report not existing and how that's not really for us. The request seemed clear on that point. So for me, if it was made differently, I want records related to, then it's a different request.
Records related to drafts of, you could have that conceivably in the request. And that might be where 6724 kind of comes in, is if someone asks for the drafts, well, under certain circumstances, you're supposed to give the drafts. I don't know if you have to actually say the word drafts in order to take advantage of 6724. Don't know. But I don't know if we need to get there on this.
Yeah, I don't think we have to. I think there's basically a good faith effort to respond to the request. And then when there's a complaint, there's like a little more like over and above, well, we do have this, if you want to look at it. Even though
Yes.
this is all we have. So I will go ahead and make a motion to forward this. These are public records under our jurisdiction, and then we're forwarding it to the consent calendar with a recommendation of no violation.
Second.
I'm sorry, the second was by whom?
Me.
Seconded by Chair Schmidt. Moved by Vice Chair Stein, seconded by Chair Schmidt, to find that the task force has jurisdiction, that the requested records are public, and to refer the matter to the consent agenda with a recommendation of no violation. Taking public comment. Anyone in the online community wishing to make public comment on this motion, please raise your hand in the app or press *3. We have no one in the room, no hands raised. Taking the vote. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. 3 ayes, motion passes.
Okay, thank you to the parties on that.
Item 8. File number 25100, complaint by concerned San Francisco residents against the Department of Public Health for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a public records request in a timely and/or complete manner. For the record, an initial response was received from respondent, too late to include in the packet. It has been provided to you by email, and the packet that's online has been updated.
All right.
Do we have petitioner in the room? Please raise your hand in the app or press *3 so that I can identify you. I'll give you a moment. Respondent has been added as a panelist. Not seeing a response from petitioner. Giving it one more try.
So who are we looking for? Concerned
Grant.
SF residents.
Grant Review is the concerned SF resident. He's raising his hand.
Oh. Okay.
Same complainant. For clarification. This is the same complainant as in file number 25099.
From
Yes.
DPH records, yes.
Yes, same complainant.
Okay.
Thank you. The parties are present.
Okay, so the named party is concerned San Francisco residents. And so that's who we're going to hear from first here. And DPH is also here. All right, when the timer is ready.
Petitioner, are you ready for your 3 minutes?
Yes.
Your time begins now.
Good evening. This pertains to records related to facilities operated by nonprofits via the Department of Public Health. I'm asking for a finding of violation because it has been 47 days since I filed this request. The department has still not produced a complete list of facilities in the neighborhood, nor the complaint logs requested. I filed this request on October 30th. On November 10th, the department invoked a 14-day extension claiming they needed to consult with another agency. However, my request was for executed operating contracts from the department. This may have been an improper extension as these are standard responsive documents. Then the department produced 0 contracts by their own extended deadline of November 24th. They only released the first contracts on December 5th after I filed this complaint and after they received the notice for this hearing. This timeline suggests the department only prioritized these records because of this committee's involvement. The department may argue that there were questions about the geographic scope as their response was narrowed from the neighborhood's official boundaries to 1 zip code. The department submitted their response to this committee today, just hours before this hearing started. They have had my objection regarding their use of a single zip code since December 5th. By choosing to respond only now, at the last minute, they have prevented me from reviewing the justification for narrowing the search. Most importantly, the request remains incomplete. Despite releasing many documents last week, this remains incomplete and the department has still not produced a single log of public complaints referenced in Part 2, Item 4. They have not addressed whether they exist or provided a timeline for their release.
Thank you. Okay, when the timer's ready, Department of Public Health.
Mr. Lim, are you ready for your 3 minutes?
Yes, I am.
Your time begins now.
Thank you, Victor Lim, Assistant Director of Public Affairs and the Custodian of Records for SFDPH. We are responding to Grant Review's protest right here, and we are kindly asking that the task force consider dismissing this complaint. We do deny that it was responded. We responded in a timely manner, and we also informed them that the requester that we're giving it on a rolling basis. So the timeline of events was that on October 30th, he submitted the request at 8:30 p.m. We received it the next business day. It was considered received on October 31st, Friday, with an initial due date of November 10th, Monday. On Monday, November 10th at 4:06 p.m., we did provide a written response that we needed to invoke a one-time 14-day extension to consult with other city agencies. And on Monday evening, November 10th at 11 p.m., Grant Review sent a message rejecting the 14-day extension. Subsequently, on Saturday, the 15th of November at 5:30, Grant Review again sent a message informing us that he was going to file a complaint with SOTF. On Monday, the 24th, we began producing the first batch of responsive records to the scope of his request and informed the requester that additional documents would be provided on a rolling basis. On Sunday, the 30th of November at 2:15 p.m., again, Grant Review sent a follow-up message expressing his concerns with the materials provided. Understanding the scope of his concerns on both occasions, we subsequently worked with the subject matter experts in our department to best identify responsive materials specific to the scope of Grant Review's request sent on the or clarification on the 30th of November. On Friday the 5th, we released the second batch of responsive documents to his request. The scope is extremely voluminous and broad. We gave more than 130 documents on the second batch, 7 on the initial batch, and we reiterated in writing that we'll continue producing responsive records on a rolling basis. And on the 5th of December, he then followed with another message. He started clarifying the scope of his request, and upon receiving the message, we again consulted with our subject matter experts to best revise and to address his matter. And as some of you may know, we've also been inundated, unfortunately, due to the murder case at the General Hospital. So today we finally got some time to respond to Mr. Grant Review, hoping to try to get a list for him on the revised scope and get more responsive records. Thank you.
Thank you.
Thank you.
Okay, we may have questions for the parties now. Okay, I have a question to the respondent.
Yes.
Just sort of basic. It sounds to me like you have produced records, and I just want to check. It sounds like you're still in the on rolling basis period where there may be more records that will be produced on this request. Am I correct on that?
Yes, and not having working with with Grant Review before, I do want to commend. He's very sophisticated and extremely detailed oriented because he has another open case with us, and we're working closely with him. We do, but he was asking for a list of facilities, and initially we were working with the Behavioral Health Division. And I wasn't clear what this American Community Neighborhood Boundary Map was. Grant Review did, as a courtesy, provide us a specific link and a defined map recently on his December 5th response. Again, I was about to say we were hoping to respond on the same day, but as you know, there was that unfortunate death on the 4th of December. And all of us got redeployed to help with a lot of the responsive efforts, documentation, and also we've gotten a lot of public records in regards to Ward 86's unfortunate incident, right? So since that's passed for more than a week, we are now coming back to re-review. And I do want to apologize to Grant Review that I think in hindsight, my team could have been more proactive in the initial time when he submitted on the 30th of October to seek questions of clarification. And as members of the task force, this is not the first time we worked with individuals here, and we often strive to have a good customer service approach to anybody. And so hence in today's response, I did give him my work cell. And if he wants to call me directly to work out the nuances, we're happy to do so. The other thing is that with corrective action letters and corrective action plans, given it is in DPH, in other circumstances for similar type facilities, there have been potentially PII or PHI information. And so as we were trying to get a list of things using a partial zip code 103, which grant review did indicate that that's not inclusive of the entire SOMA district that he's looking for. We are going back to offer that. Unfortunately, due to the software limitations, we can provide a list of 103, 105, and 107 areas for the list of facilities. It may encapsulate more than what he's looking for, but if perhaps we can work out a way to sort it out, or if he knows the geographies, to let us know which ones he would like to choose, and then we would proceed specifically with all the CAP and CAL reports responsive to the list that he's amendable to accepting.
Thank you.
Thank you.
Well, we might as well think about deliberation unless, questions come up.
One quick question.
Sorry.
For the petitioner, so you said so far you've not received any log of public complaints. Categorically, is there anything else that you think is completely missing right now?
Not completely missing, but I will say that the definition of the SOMA neighborhood is the same as what the city uses as an analysis neighborhood. This was not a complex request, and we're 6 weeks in. So I say that because I do not have even a list of the properties, let alone their executed contracts. I do not believe this is a complex request. Maybe the corrective action letters might require discovery, but each one of these contracts is multi-millions of dollars each, and was passed by the Board of Supervisors. They're readily available documents.
Okay, thank you.
And you believe that there are executed signed contracts that you asked for that you haven't received yet?
They have admitted that they have only provided contracts for zip code 94103. And we know that that is just one part of the SOMA neighborhood.
Okay. Thank you. Well, this is actually, I'm just going to note that we're 6 weeks in, and we're actually we're having a hearing on this, which is, that's 42 days. So that doesn't mean we're going to necessarily meet the 45-day period, but we do have the department is engaged, I think. And we have seen other departments where it could be a much longer time and they would not be engaged. I'm not saying that we shouldn't be holding people to the deadlines, but maybe because we're moving faster, we're changing the timelines that we're seeing in these public record requests. it seems to me that this is one where there are going to be more documents that are going to be produced. There is there's a time question of is the time here satisfactory? Do we find a timing violation? I think maybe we would also, since it's our job to, order the production of something that hasn't been produced, we probably would recommend, or if we put on the consent, say, well, we need to have an order here that they continue their rolling production until, everything is produced that's responsive. It looks to me like maybe there's not that much else here. I think that's kind of what this case looks like to me. It's just a question of, like, how do we send it on to the task force? Anything I'm not seeing? I often don't see the forest for the trees. Give me the forest.
Could I ask a question?
Quick question, sure.
Could we discuss the extension to consult with other agencies on executed contracts that are held by the department, which was the initial 14-day extension?
Well, we're thinking about, we're taking that into consideration, whether they actually, satisfied what they said they were going to give you on that extension, and whether they did what they said they were going to do, which is the reason they needed the extension. I don't think any of us are real big fans of that 14-day extension. And there's certainly some of us who think that maybe that's not allowable in San Francisco, but we're not necessarily making this case all about that right now. I think partly because this is a case that does involve both a timing issue and documents that are sort of coming in stages. What we could find is basically a delay finding in terms of the timing. I'm not sure if we would do much more than find a delay violation and try to make an order that would get you your documents as soon as possible.
This is Victor Lim from DPH. May I make a comment?
Yeah, I'll let you. Yeah, it's fair. I'm gonna make this our last comment unless we have questions. But please do, Mr. Lim.
Through the chair, Victor Lim speaking again. I would like to just reiterate that, we had to consult with some of the other agencies because the initial request also listed out homeless shelters. We needed some advice also from HSH, and also, again, with trying to figure out the nuances for this request. As I'm the custodian records, we help shepherd the process. And as you've heard before, I often have to work with other subject matter experts to better figure out the definition and the meaning of the scope of the request. Now, as we did invoke the extension, we were on time to provide our first batch on the 24th of November, which is the 24th day from the initial response. It could have been more. However, as we, I think, reviewed the scope subsequent to Grant Review's 2 comments after receiving the initial batch, it was helpful for us to further engage, discuss with our behavioral health division staff to get the right documents. And I would say that it may not be to a satisfaction that there's a list of 94103. It's not the intention that we're trying to hide something. As a matter of fact, the list, I think the staff was trying to explain to me that, you know, some of it's dated, the definitions have changed a little bit. And so on the back end of this, it's a little bit complicated. If we could overlay the a geographic what do you call this, geofence, the SOMA the American Survey definition of SOMA into our software system, that would save us a lot of time. Unfortunately, the back end allows us to only sort by rigidly with the zip code. And I do want to mention, if I do include 94107, there is a large portion that spills into the portrayal, which may not be what necessarily, obviously is not included to what he's looking for. But I would like to work with grant review here, that once we give the list and we lock down which, if he is satisfied with the list of the facilities, it's going to be very easy for us to get the remaining portion of any facilities that were not encapsulated in the 94103, which is part of 94107 and 105, closer to the entrance of the Bay Bridge and that section of Upper Soma. We will complete this. We are not trying to hold back anything, and I do apologize if the delay has been frustrating for the requester.
Thank you. All right, I'm going to make a motion, which is, based on the circumstances in this case, since we can't decide anything, I'm going to move that we find that this case does involve public records. We do have jurisdiction, and we're going to send this matter for a decision by the full task force on the questions of whether there has been timely production of the requested documents, and whether there is a need to issue an order to produce.
You agree with that?
I think it's enough of a question that I would send it
to. Tell me what you. That's my motion. So until it's seconded, it just sits.
Yeah.
No, I understand. Go ahead and tell me what your thoughts are.
I want actually to be convinced that there's a violation. To me, after hearing from the respondent just now and looking at the documents and looking at the case, I was prepared to recommend, like, not necessarily motion, but recommend that, like, we send it to consent without violation, just because I don't know. The timeliness issue is a question, but the respondent is obviously trying to produce the documents and cares to do so. And so, like, our position can, in instances like this, if we think that there is some obstruction for that, then we can say that there's a violation in order to tell them, like, to signal, please be more effective at this. I just don't see that they're not, personally.
Okay. Yeah.
That's just my take. I was wondering.
No. That's.
I think there's a lot of documents being asked for, and maybe it's not always clear. But I mean, because of the way the data is being collected, but like some of these things, yes, for instance, like contracts or in certain zip codes, like I'm not sure why some of that couldn't have come in the first 10 days. And I think, extensions were asked for and all of that, like within kind of the proper amount of time But I think there are some things here that are pretty, clear, probably, like, at least for the zip codes that were, presumed to be relevant at first. So it does seem like 5 weeks is a little bit long. I mean,
Yeah.
there's different documents here, but they are, fairly well defined by the petitioner. But I mean, I understand why it's a hard case. That's why I would just say maybe send it to the full task force and let it be discussed there, because I feel like we're trying to send to the consent calendar things that are like really clear cut.
Okay.
Second? You want a second? Okay, and
I'll support it.
I think it's more about like, I don't know how we would put it exactly on the consent calendar and if we'd get, sort of consensus even here.
Mm-hmm.
So since it could
No,
go
I know.
different
No, I'm not. No, I'm not. I mean, it's for further consideration. I wanted to, because the respondent is trying to produce the documents.
Yeah.
I wanted to spare furthering the case in this instance, but I'm happy to support furthering, like to give it further consideration in front of the full board.
Yeah, and I think I agree with you about, I think that there is a good amount of cooperation here from the respondent. It's certainly not one of our, there's some cases where we get people who just are not with it. Yeah, but that's not what this is. Okay, so we have a motion and a second.
Moved by Chair Schmidt, seconded by Vice Chair Stein. To find that the task force has jurisdiction, that the requested records are public, and to refer the matter to the full task force on the question of whether there has been timely production of the requested documents and whether there is a need to issue an order to produce. Taking public comment. If you are in the online community and wish to make public comment on this item, please raise your hand in the app or press *3. We have no one in the queue. Taking the vote. Chair Schmidt.
Aye.
Chair Schmidt, aye. Vice Chair Stein. Aye. Vice Chair Stein, aye. Member Sugarman.
Aye.
Member Sugarman, aye. 3 ayes, motion passes. Item 10. Thank you, parties.
Thank you, the parties.
Good night.
Item 10, file number 25109. Complaint filed by Anonymous against Supervisor Connie Chan, Board of Supervisors, for allegedly violating Administrative Code Sunshine Ordinance. Oh, no section number. Just a moment, please. The agenda does not mention a section number. The complaint in the published packet references sections 67.29-1, 6729-7, and 6721.
I don't think that's a concern. I think it's pretty clear as to what this one's about and what the potential violation numbers would be.
All right. Thank you. One moment, please. We have a hand raised. We had a hand raised and the call appears to have dropped. Let me see if they have been moved to panelist. Hello, caller. Are you a party to item 10, file 25109? I'm going to go ahead and unmute you. Hello, is this Ms. Burke?
Yes, this is Robin Burke from
Burke.
Supervisor Chan's office.
Hello. Thank you, Ms. Burke. Do we have petitioner here?
Petitioner is listed as, I think it's anonymous on this one.
Yes. Doesn't appear, petitioner doesn't appear to be present.
No petitioner? Okay. Well, that means that we'll be talking about whether we dismiss, table, close the file. Close the file.
A 7B closure?
Yeah, and just since it's, I don't feel that bad about closing this one because it didn't look like there actually would have been much of a violation. I don't know what the other people here.
I'll just say I had it in my notes that just based on the reading of the case, I was going to recommend to take no further action and close the file. I think this is, I didn't see a records request per se. This is about, if there's some responsibility to maintain, first of all, to treat like social media as a public forum, and then also to maintain those records for some period of time, although this account was already, I guess it was closed in 2022.
Yeah, exactly.
Those records don't necessarily need to be bound forever, but I think that this really isn't even under our jurisdiction. So I was going to just say take no further action and close the file.
Yeah.
The petitioner was not here, but because it just didn't seem like the case for us.
Yeah, it's questionable whether we would have even really had jurisdiction on this. Although, well, one is we don't, in the committee here, we don't decide anything. I guess if the petitioner doesn't show up here, can we close the file? This is not the full task force, so I forget. Have we done it before? Okay.
Well, I know that we've moved the table. Technically, we usually say that
in committee.
That's usually what I remember. That's what I recall.
Okay.
I'm sure we've probably also. I can reasonably assume we've also said close, but I usually hear you say I moved to table the matter.
Okay.
Like that.
Yeah, let's do that. Let's move to close the table. I mean, table the matter.
Is there a second?
I second.
Seconded by Member Sugarman. If you're in the online community and wish to make public comment, please raise your hand in the app or press *3. We have no one in the queue. Taking the vote. Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Vice Chair Stein. Vice Chair Stein, aye. 3 ayes. Motion passes.
Okay. So sorry to Ms. Burke. I don't know. We've got to figure out a way to not cause people to have to sit through and then there's a no-show. That's just it's just not acceptable. But hopefully you won't get it a second time from us.
No, thank you so much. I do want to say that we sent over. We do have maintain the downloaded archive of the supervisor's tweets from when we were using Twitter.
Yeah.
and sent it over. So we do, think that it's important to have transparency and have maintained those, even though it's, beyond the record retention requirement. But and we'll make those available upon request. But just have chosen not to engage in the Twitterverse anymore after certain people have taken over.
Got it. Understood. Thank you.
Thank you so much. Have a wonderful night. Okay, bye-bye.
Thank you, Ms. Burke. Item 11, hearing re-advancing the Sunshine Ordinance Task Force, section 67.30 roles.
Let's do it.
Okay. Is this where I get my fabulous one-page?
No, that's the next one.
Oh, that's okay. Somehow it got my one pager for this one got put at the next one, I think.
Uh-oh.
But my one pager, which just has like about 8 ideas, is the thing that I thought I would put into the file, and then we could, just sort of like do an up and down vote on what we want to send.
That's under hearings on bylaw amendments to improve efficiency. I thought it was
right.
So, right. So we'll do that when we get to 12.
Well, yeah, but we have the 6730 rolls is the one we do to like usually on this topic.
Yes.
So like we should just move to 12. Then.
Yeah.
No.
Oh
yes.
Oh, okay.
I really dug into this one this time.
All right.
Because
We're still on 11.
Sorry.
It's fine.
I'm sure it's 9:13, but
I'm fine to stay, by the way. My focus is definitely like tapered off a bit at this point, but I want to talk about like the important things tonight.
mine has 2, but 6730, that's the thing of like all the things we're supposed to do, right? As opposed to how we go about doing them efficiently or not. And for some reason, I dug into this one this week, and I was looking at 6730, and I was thinking about our committees, and I was thinking about what 6730 wants us to do, and what aspects of those seem to happen in committee, and what aspects of those don't seem to happen at all. And I also just looked at like how our committees are described, and I just thought, there is room for rethinking this at some kind of fundamental level. And I had a couple ideas I just want to throw out there. One is we don't have our committees report on what they do. So, what is education and, training done this year? I don't really even know, right? Or what's taking up their time, what they think has been fruitful, what's not been fruitful. And so I was thinking maybe if we are going to think about what really needs to be done outside of just hearing complaints, we might want to start with like asking committees to report at least once a year. What did you actually, what did you do this year, right? And that would also help us maybe redefine the scope. And I also saw that I feel like a lot of what our committees are supposed to do is just very general, the way we describe it. And it's also very overlapping in some cases. Like, they're all meant to be looking at 6721 complaints. A couple of them are meant to be looking at compliance. And it's like not clear, like, are they just, are things just doled out to whoever if it falls under those headings, or do they have something that they're really focused on here? So, I looked at the Board of Supervisors rules that Victor shared with us, and they're much clearer on what each committee is there to do. And not saying that we would just copy from that because it's completely different, but I'm like, maybe we need to be more clear on what the committees do. And then that's kind of slightly complicated by the fact that I know the clerk's office doesn't really believe we should have committees, that they think we should just have a task force and nothing else but that. But maybe it would even be more palatable to them if there were fewer committees with clearer descriptions, for instance. But I just want to say I know that that's been a point of contention. But basically under 6730, these are the things we're supposed to do. Well, no, maybe I should start with our main activities in committee. I'll just start with that. as opposed to what 6730 says we're supposed to do. But basically, we've got priority review of 6721 claims. Looking at rules, it's asked to amend task force bylaws and procedures. Although I want to say this rules hasn't met for like years, and these things seem to come up pretty organically and then kind of get assigned to committees to look at. So like, do we need technically a special committee for that? Monitor compliance with orders of determination is both under EOTC and CAC, and yet, nobody's really fully monitoring compliance. Right? They're just sort of following up on things and trying to make sure documents are gotten, but there's no record of what the compliance
Sorry,
is.
I have to interrupt just at that point. Who is following up on things? Like, we know who's supposed to be following up on things, and I'm not trying to like point fingers, but is there any follow-up actually happening right now?
I think CAC does try to, things get sent to the CAC if they specifically say it in the task force meetings that, CAC will expect a letter and follow up and see, whatever, then it happens. But I don't know that besides that it happens necessarily. But
I want to be able to see those letters.
Report from CAC, then we would know like these are the number of things we followed up on or something. I don't know. And normally committees do report to full boards, right? They're not just doing stuff and no one else on the board knows what they're doing.
Yeah.
Yeah. Right now, EOTC and CAC are supposed to monitor compliance, but we don't quite know exactly what they're doing. And there's not any kind of comprehensive monitoring of compliance. And again, I know this is something maybe the clerk's office doesn't even want us to monitor compliance, but I do think it's there in the Sunshine Ordinance that we are supposed to be monitoring compliance. And so what would that look like? And this is why I kind of went back to this, because I feel like it's just such a big missing piece. And then we're supposed to maintain education and training for the city and the public, which I honestly don't think happens at all. I think and even when we try to make it happen, it doesn't happen, right? So there's a committee that's supposed to do that, but it doesn't really happen. And then that committee is also supposed to make recommendations for outreach and media publicity, but I haven't seen any come out of that committee in the full time I've been on the task force. I mean, it's kind of come out of our committee, but that's technically not what we're supposed to do. And then we're supposed to monitor the complaints process, which in practice seems to mean that we do all the pre-hearing of all the complaints, which to me is not really the same thing necessarily as monitoring the complaints process. And we're also supposed to make recommendations about how complaints should be handled, which technically we would be doing under item 12. Yeah. We're suggesting changes, and we actually really are under our current kind of remit. So the Sunshine Ordinance then has its things that it says, basically says we should provide information to city departments on how to implement the Sunshine Ordinance. I don't think we've done that much. And I think some departments really are hungry for it, and they've kind of put together their own working group to try to figure out what it is that we want when they come before us. Although I do want to say, and Pat, I want to mention it too, like I didn't see in this any of this material here, like we were for a while sending a kind of form letter to the respondents about how to respond to complaints. I don't know if that's still being sent or not, but it has really specific things like, describe your search process. Tell us if this happened. Tell us if that happened. Is that something that still goes out?
I do not send something like that.
Okay, 'cause that was there in the past, and I feel like that would help kind of speak to that issue of helping them implement, right? Like Lori, Neighbors and I, when there was a rules committee, developed it. And for a while it was going out, and we looked at it, about 50% of the respondents were using it. And it was leading to like more complete answers, clearer answers. And I think it was some guidance from us. Then we're supposed to advise the Board of Supervisors on how to implement, develop goals to ensure timely implementation, propose amendments to the Board of Supervisors, which I guess is, that's kind of happening in a committee right now. Report on practical policy problems. Now we're doing that through the annual report. Make referrals to municipal offices with enforcement power. If we deem that any person has violated the provisions of the Sunshine Ordinance. I mean, right now we do that to ethics, but we have no way of tracking whether after we put out our orders, whether people are still, violating or not. And maybe that's an avenue that we should pursue.
I always thought that was supposed to be part of CAC.
Yeah, maybe it is. So I feel like this is like something we could do under this heading is really kind of say, like, let's really look at what's happening, what's being done, what's not being done. Let's really clarify what the committees should be doing and let them get on doing it. So I kind of just went to town with this item this time.
Yeah.
Because I just really wanted to kind of go and look and see what was happening. And I always felt when I looked at these committee descriptions that they were like overlapping, they were kind of vague, some things were happening, some things weren't happening. So I just wanted to throw that out there under this item.
I feel like there's so much there that's like that feels true. And also, if you went and, for example, brought it up at like the main board meeting or sent like an advisory letter to like another subcommittee, like, what are you doing with this item, that it would look kind of adversarial. But possibly like it might make sense to do something like that in the annual report, like to talk about like specifically what's like the status of certain committees and what they've accomplished, and what they should potentially, an evaluation of what they should be doing.
Yeah, I mean, that could come up, but I would like to just start with having them just report to the full task force what they're doing. Like,
That's
it would be
good.
informative to all of us to know what each other were doing, don't you think? I mean,
No. That's
Yeah.
no, I agree with that.
No, I'm not saying we didn't, but I don't, I feel like I want to start there before even thinking about putting it in the annual report. But yeah, it could be in the annual report that if the committees do a little, quarterly or end of year report on what they did, a little paragraph, like that could easily be in the annual report.
Yeah.
I don't know if the supervisors would really care. Maybe it's like more really internal to us, but yeah.
Are we required to be on committees as part of our roles?
I don't think so.
Committees aren't even required to exist.
Yeah, exactly. And it seems like it's kind of an inertia thing, like they never change.
Yeah.
And it if it were up to me, the committee's stagnant, you get rid of it, which is kind of like what the commission
Well, I think that like the concern there is, well, I would be predicting a concern that if you did that, then other people would say, well, if we get rid of it, what if at a certain point in the future we would want to bring it back, or it's of use.
Yeah.
But in your comment about inertia, it does feel like if there are these committees that aren't if they're not meeting or if they're not performing specific actions, then what's happening is people are automatically being assigned to them anyway. Like, it's not a thing where if they're not in use, then like if it would be a different thing if it was a committee that existed but we weren't using it, and that way it wouldn't be necessarily like a cog in the system. But it would still be an option to have, right? Versus like what seems to be happening, someone joins, it's like, well, what committee are we putting you on? Which is, I mean, I've seen it. It's not just with me. It's with anyone who joins the force. It's like, well, where are we going to place you on committee? So, I mean, it is.
But to me, the bigger issue is the lack of clarification of what committees should be doing specifically, and things that are falling through the cracks, or things that are not happening at all, or some of the things that are not happening at all, or some things happen like ad hoc. You know what I mean? Like if something comes up, like we're discussing, this, we really want a media presence, for instance. That's like a special topic that can be assigned to a committee that already exists. There doesn't have to be a long-standing committee to handle that topic. So things can be delegated from the chair to particular committees that are existing and doing like something ongoing.
Personally, compliance and education are like the most important ones to me. So like, I would want to know who's performing follow-up, what follow-up is being done in terms of complying with whatever orders were given. That's number one. And then education, because like what the mayor's office said today, like, well, I've let them know what could be sunshined. And it's like, of course the mayor's office or any city office should do that for the agency, but it's like, why aren't we doing that? Why isn't there like someone, part of our body that goes to each main agency and says, it's the new calendar year. These are your sunshine rules. Like we need to talk to the person who should be in charge of this to let them know that we've educated you about this and asked you to educate the people in your department about it.
Well, I mean, they do have, there's a sunshine training, right, that everybody has to take. But it does seem like so the rules are out there, I guess. But I think the place where I've seen a lot of confusion among custodians, they don't always know what they're supposed to do when they come before the task force. I think that earlier letter that we used to send helped a little bit, but they don't really know what to expect, what we're looking for, what what they need to provide us. That's like, I think the bigger thing. But I was gonna say, even this whole thing that just happened with, ethics and having our members go and try to see what it is that ethics is saying and doing, and are they following? Like, to me, that probably should have been under education. Like, people from the education committee should maybe have gone and done that, because that would seem to fall under, their purview. I'm glad the people who went.
Yeah.
Yeah.
I have a super hot take. That training is a DMV video.
No, I know, but I think it's hard to ask to do extra training.
I'm just saying, that is not a training that
Yeah.
I'm putting it on the record that training is, I'm grateful it exists. And also you are being asked to watch and absorb something that is a very thoughtful DMV video, but nonetheless is a rote thing to watch and try and study. And if it were me, in a city agency, and I wanted to get information, these agencies want information on, they come to it and they're like, we didn't know we were supposed to do X, Y, Z. Then I would want someone from our committee to go to them in, like I said, in a quarter or in a calendar year and say, listen, these issues are the ones that we most see. You're going to see something potentially on rolling production. You're going to see something on immediate disclosure requests. You're going to see something on extensions for immediate disclosure requests, things that actually come up for us that they're not routinely performing, versus an hour-long video that says, this is the Sunshine Ordinance, and this is how the Sunshine Ordinance works.
No, I know. I don't think it's the best either, but it is mandated training. But I was just thinking something like, what's it? Oh, like IDRs. These custodians have got together, came up with what they think are best practices around IDRs, and that particular group of custodians tends to follow it. But there are a lot of other people that get ensnared by IDRs because they just don't have someone, watching an account or whatever it is. So even going to having a call with a department afterwards about here's what would be best practices and here's what we suggest, or some, that to me would be a useful education that we could provide potentially. But
you could also look up the departments that have the largest number of sunshine violations in a year, or the number of sunshine requests in a year. So you could actually do directed training, for example, with the San Francisco Police Department, because so much comes before them, that you could actually have an actual a scheduled conversation specifically with them and with the mayor's office.
Sure. Yeah, or a new mayor's office when they come in, you can say this is what we're looking for. But yeah, so I'm saying it's just education and what do you say? It's most
compliance. Those are my two areas where I'm just
two different groups are sort of doing compliance, and compliance, as I understand it, just from having talked to people on compliance and amendments, it just means we try to follow up if there's some follow-up required. But if there's not, there really is no follow-up. If it's not directed by the main task force that this is what you're going to do to follow up, there is no follow-up.
Yeah. The average city employee has to take 1 hour for a year or whatever, every 2 years. And a custodian has to take the same 1 or 2 hour training, a custodian of records. That doesn't make sense. A lot of what we're talking about, we might think about that video, the DMV video, and do we want the average city employee to do something more than that? But also, maybe the custodians of records shouldn't just be watching that 1 hour video, and maybe we should be educating them. And, you know, the video, I don't think this task force had I don't think it had any involvement in that video.
No, and they don't want us to have any involvement.
Exactly.
Like when we've tried to have involvement, they don't want it. So,
Yeah.
and the other problem,
And
I
it's
guess.
part of the statute, I think. You know,
Yeah.
we would do training.
Right, it is part of the statute.
Yeah.
But maybe that's not the training issue because they don't want us and maybe we don't even think it's effective. But the other thing we have to kind of be cognizant of on education is that we're not supposed to really be creating like extra burdens for employees or whatever. But I think it's something that we could offer as a option.
Yes.
They mean?
Yeah, something to offer.
Hungry for it.
That's what I was about to say is that it reminds me of a time as a legal affairs journalist that we were invited to sit, several of us were invited to sit on a panel with the public defender's office. And they asked for that. And all the public defenders came and like sat around and asked us all these questions about what it was like for us to cover these stories and how we release information, what we're looking for from you, and what sort of things qualify for us as like stories that we're going to run really, you know, far with. And it's just like, I feel like if you had something like that for the Sunshine Force that was just like, we're offering for 2 or 3 of us to come and sit on a panel for your office to ask us questions about what comes before us and how to comply with the Sunshine Law. I actually don't think that like there's more than a zero number of offices that would be interested in that sort of discussion with the Sunshine Force.
I think that's true, but I don't know if I want to, I mean, how much I would want to micromanage like what the different committees necessarily did. But I think if there was a description that was a little more detailed about things that fall under the purview of education, and if there was a, you know, an expectation that maybe once a year or every 6 months you report to the full board what it is you're doing, that some of those things might get, you know, the engagement with them might get a little deeper and more thought through and just not fall between the cracks in the same way. I don't know.
Yeah, I don't know how much the task force does E, O, or T right now. It's pretty limited. It seems like it's definitely, whether it did it at some point and the statute talks about doing the education training, it's like almost zero at this point.
No, I know. Yeah. I had this kind of, I mean, that was the committee I asked to be on when I joined, but I wasn't put on it.
You got stuck on this one.
You know, I have these fantasies that committee would like, you know, maybe send people out to organizations to talk about what Sunshine is and how they can use it. And you know what I mean? Like things that really would be outreach about, you know, because I feel like we do get same kinds of requests from, you know, 50% small group of people. And I feel like it's not necessarily getting used to the best of its, you know, ability, and that people who maybe could really use it don't even know about it or how to use it, or it's too intimidating. So I feel like those are the kinds of things that I would love to see too. But again, I'm not on that committee and it's kind of up to who's there, but I don't know anything that's happened in, like, I don't know any education or outreach except for these like occasional memos that go out that are like kind of long, dense 1-pagers about, you know, I think once or twice that's happened, but that's not even come out of EOTC. That's just come from the task force.
Yeah.
I mean, not EOTC. Yeah, I guess it is EOTC, education and outreach and training.
I wonder if we should rotate. I don't want to. I'm not saying that I'm not saying that I even endorse this idea in the way that I'm suggesting it.
Rescinded.
I don't want to rescind it either because it's kind of the same. For me, it falls into the same bucket as term limits, that discussion. Like, we're not really rounding the board by us being siloed into these committees. Like they're like the people we're not experiencing that on EOTC or on compliance, where we could be having this voice there, but we don't want to because we like having our voice here.
In other words, people should not be stuck on one committee and never move to another one. They should.
Yeah.
They simply.
Like I
should.
said, I would like to stay. But I still think that there's what I would like versus what could be appropriate. Like it might be better that we did rotate.
But I was thinking today, like, how useful and maybe necessary it is to have a lawyer on this particular committee
Oh, it is.
to pre-hear these cases, to like, you know, I mean, sometimes the way you question and like your special knowledge on certain things is extremely valuable for like the first look at these cases.
Plus now with the consent calendar, they're not entirely, because we can't make decisions, but they're kind of like bench trials, you know, so.
Yeah.
But what do you think, just to start, of like, you know, like if I were to ask Chair Yankee if he could put on the main task force agenda, like a report from the committees at the end of the year about what they were.
Absolutely. Yeah. We should have that. We should all have to report something.
I don't think it needs to be a motion. I just think I can ask him if this is something that.
Yeah. And I, you know, we could even like just sort of do a line by line 6730 item at the board. What are we doing for this?
Almost like an audit.
Yeah. Like what the hell's going on with this? And who is supposed to be doing this? Because we all assume, oh, well, he'll take care of that, you know, and it's like, you know, it's our job to be like thinking about all 8 or 9 of those items. That's on 6730, because it's not like, you know, you could say, oh, I just do that. I do that. No, you're supposed to be on this whole task force just like everyone else.
Yeah, and I do think the Sunshine Ordinance is written pretty well. And the more we can align ourselves to what it says we should be doing, you know, the better.
Yeah. Let's do that. Let's get an item on, and the one about the committee's reporting. Absolutely.
Okay.
Yeah, that's a good item.
I would just love to start it as an information gathering process to kind of think about this
Yeah,
further. I don't
sure.
have any
That's fine.
specific.
Yeah.
So I can do that. I also just want to mention that I actually did have coffee with Chair Yankee last week. So when we talk about our next item, I have some additional ideas.
Okay. Yeah.
I mean, obviously I didn't see this item at that point, and I wasn't talking about any specific proposal, but he gave me his ideas about ways to maybe improve the process too. All right, that's all I had to say.
If everyone want to move to 12 then?
Yes, please.
Okay.
Taking public comment?
Yeah. We didn't do anything, but we did a lot, but public comment's fine.
If there's anyone in the online community who wishes to make public comment on item 11, please raise your hand in the app or press *3. I'll give you a moment. We have no members of the public present. Item 12. Item 12. Hearing regarding proposed bylaw amendments to improve meeting efficiency.
Okay. All right. So what I did here is I sort of thought that everything that we were talking about kind of would be in this part of the bylaws. So I didn't do anything with the rules, the complaint rules. And each point in here where I sort of offered an alternative was an idea that we may adopt as a recommendation or not. We may talk about it. And then I took and it generally tracked what we had been talking about. And then I took the 2 items that Victor had mentioned, and I just sort of like cut them down a little bit and made them more appropriate to us. I'm not saying we necessarily would like either of those, but they're worth mentioning. One thing I think that we should do in order to win is consider offering each one as an individual proposal to the task force, voted up, voted down, and then it's like it's like you basically, it's not like you vote for them all or none, and so we might win on some, we might not win on others, but we don't cause ourselves to lose on everything because there's one part of what we submit that nobody likes. So anyway, you all want to handle this? I figure we can create a list of things that we'll put before the task force as sort of maybe individual items to be considered and voted on. I threw in the cutting down of the presentation. I threw that in, even though I know that we don't all necessarily want to do that. I understand that. And so we may not approve that, but I just threw it in there anyways, the 5 minutes becoming 3 minutes, 5 minutes becoming 3, partly because I was going through this and I was looking at, okay, we make these changes, like, how much does this really do actually? Like, and compared to how long an entire hearing is, how much do any of the changes we're doing actually make? I don't think people actually use all 3 minutes for their rebuttals. They say, I don't have rebuttal most of the time. So it's not necessarily like the greatest change, like it's going to make a huge difference. But if we really want to make our hearings shorter, well, maybe we're going to have to take some pain. And, like something's got to go. We can't have it all and yet make it shorter. So that's why I kind of was more inclusive than exclusive on these things. So anyone who really likes something, maybe you pick it out and we'd figure out, do we all agree with that one? I figure we all kind of liked the one on number 5. I think we all kind of liked the one on number 4, the changing from 3 minutes to 1 minute for rebuttal. I took out discussion and questions to parties to just say that we are just going to do questions to parties. That was one that I thought, discussion, that kind of allows certain people to talk for a long time at that point, and maybe we take out discussion. Yeah.
Okay, so I have some questions.
Yeah.
With the task force okay. The part that you put, after 30 minutes have elapsed in the hearing, deliberation will be limited to offering of motions and decisions thereon. I understand what you mean. My question is that specifically the deliberation portion? Q&A is done and now we're deliberating.
It could be, like any of this can be altered, before we get done today. What I thought is that that's from the point where the case gets called. That was which makes it, maybe 30 minutes isn't enough because, you build in 5 minutes, 5 minutes. The rebuttals are 3 and 3 technically. And then, you're going to have public comment after you make the motion. Although that's not within the 30 minutes.
Let's consider an ideal scenario. And actually in the scenario, I'm going to even though we're now at 9:45 p.m., I'm going to go look at a prior calendar, and then we're going to assign some minutes to how long this takes, at least for the complaint process. So let's pretend that we do not get the 3 minutes, 3 minutes, 1 minute. So it's at 5 minutes, 5 minutes, 3 minutes. So that's 13 minutes of presentation and rebuttal. Okay. Then how long do we want the entire thing to last? You want it to last 30 minutes? I'm going to think maybe 30 minutes. Okay. So then
for this committee.
For the board.
Oh, for the board.
We're talking about doing this for the board, right?
Yeah.
Okay.
Yeah.
So then we've now elapsed 7 minutes for presentation and rebuttal. And then how many minutes do you want for, let's just pretend, how many minutes do you want for Q&A? How long do you think that should take for 11 people?
Conceivably, it probably doesn't actually, well, some cases it becomes a lot of questions.
Yeah, I feel like
most cases, like, there aren't that many questions. I don't know how much.
Let's say 15 minutes.
15, really?
Yeah, I mean, because like for me, I am more interested in, I think that the parties want to feel heard, and that's when they feel heard, is when we're actually invested in asking them questions.
Okay.
And sometimes it takes 5 minutes, sometimes it takes longer. But the chair has been pretty good at limiting people from not grandstanding on, like their own theories. Like typically we're now limited to questioning. So I don't want to limit the questions more than I want to limit the deliberation personally. So like up to 15, I don't know. That's just my idea. So then if it's 15 minutes plus 7 minutes, so now you're at 23 minutes. So that leaves 7 minutes left for deliberation if you're sticking within a 30-minute timeline.
Okay. Well, now this is whatever time we start deliberating, there's going to be the 30 minutes is probably going to hit while we're deliberating. That 30 minute, the clock strikes 30. And that means we stop basically bullshitting. And at that point, all we can do is someone makes a motion. And does it get seconded? No. Someone else makes a motion. Does it get seconded? No. Someone else makes a motion. Does it get seconded? Yes. Vote. So I think if we know that those are the only things we can do, people's brains will adapt and they'll become more efficient in the other parts of the process.
Mm-hmm.
And that's, I think, what it would look like in my imagining of it.
So go ahead, you go.
It's just hard because like I feel like we have, it's not just our complaints. Like you have items that just go on for an hour and a half. And sometimes we have, at least especially when I first started, and I still see it happen, but like before there was a focus on moving administrative items after the complaints, you would have that happen before. You would just have something that we had in mind and it would just keep going.
Yeah. Those, are they in like hearing complaints, or are they in some of these?
And like what we're doing now. Like
okay.
that. Like
and
it would
just goes and goes and goes. Yeah. I mean,
that happened last meeting, didn't it? The one that I left around 9:30 or 9.
I made a rule that I'm not going to get involved in the talk about amendments.
Well, unfortunately,
because there's plenty already being said during those, and that's an example.
Can I throw in a few?
Yeah,
things?
go ahead.
Okay, so I want to say, I really love the limitation on speaking. And I think that really has to go, I mean, maybe it doesn't have to, but I would love for that to go like maybe first or in conjunction with some kind of time limit. But I will just tell you, when I was just kind of getting Chair Yankee's ideas about how things might improve, he raised the same idea, limitation on speaking. And he really advocated for the idea of, or it seemed to really like the idea of one go around per task force member, that everybody would get a chance to speak once. In part because he thought time limits would not be as effective as speaking once, right? And he seemed to think it's more of an issue too in the discussion phase, that some people, like, that's when people tend to really go on, and if things aren't going their way, they don't want to let it go, and so it just goes and goes and
That
goes.
part too.
And there's no easy way to just like call the question. So he had talked about one go round per task force member. I know and he also, I will just say, said the more he thought the more we can align it with like the Board of Supervisors and what they do. So Board of Supervisors allows 2 go rounds, and I know that's where you got it. And they allow 10 minutes to speak total, but I think we should be less than that. 10 minutes.
You don't want to encourage that.
No, I don't think we want to, but I think, you know, Chair Yankee just thought like just having a time limit was not going to really lead to the kind of self-policing that you're hoping it would lead to. And instead it might lead to just a couple people, you know, dominating that time. So I think it might be useful to go with that one go around idea to start, and maybe have a way of like, if the majority, like the Board of Supervisors has after the 2 go around, if you have then enough people that say like, oh, maybe you can take another turn, then you can. So there's kind of a safety valve. It's one go around, but you know, that could be one way to handle it.
The consent of a majority would give that possibility of speaking again, if under what the board does here.
So what it says in the Board of Supervisors rules is the supervisor shall not speak more than twice in any one debate on the same subject and at the same stage of the proceeding, right? So you could say one go around in the questions, one go around in the discussion. Right?
Okay, so to give an example, how many go rounds did you two just have?
Oh, I see, because we're.
Right, but.
No, what, because
no,
how, what is this now my second or third go around because I'm speaking?
Yeah, but this is a small committee.
Many,
not
yeah,
a large
many.
committee, of course, but yeah. I
Yeah.
mean, the small committees are probably the place to have these discussions, but I don't know.
I would say 2. That's all, but I still think that's going to be hard. But I would say 2.
Well, this is just about complaints. This is complaint procedures. This does not apply to talking about
The other stuff.
the minutes and talking
Yeah.
about reports and talking about amendments.
Yeah.
We're not even there today. So,
Well, I wanted to say I actually agree with Member Stein that the go around is probably a better way to do complaints. However, I would suggest that if you did that, then you would put a minute cap on the other items too, because you're still trying to get the meetings out by a certain time without saying you're getting them out by a certain time.
Yeah.
That's not going to happen if you're going for an hour and a half on some administrative item. So you could put the minute cap there, and then people can still talk back and forth as much as they want.
That's an interesting idea, and I would probably support it. But I also want to throw out one other thing, which just I was thinking a lot about after our last meeting, is maybe to have some way to think through like what items should even be on the agenda and what items shouldn't be on the agenda, like at a full task force meeting. So I think like, you know, I just realized like in our last meeting, I think you were gone by this point, but I've seen this many times where just like a bill, piece of legislation that's either pending or passed, comes on the agenda. You don't know who's put it on there. You don't know why it's on there. You don't really know what you're supposed to do with it, but you're being asked to read 30 pages of material for no clear end. And I'm like, maybe we need to have some guidelines about, things don't go on the agenda unless they're complete and they have some kind of accompanying explanation of the context, the actions sought, and the submitting party. right? And so that could be another way that you also limit, like certain discussions go on and on and on because there's no focus to them, because they're not, we don't really know why they're there. And then we slowly come to some consensus, but I don't feel like items should be on the agenda working in that way.
Yeah.
It just doesn't seem effective. Like that should be happening in a committee.
Yeah.
And I will say, when I first tried to make my first changes and I had no idea like how anything worked here, I went to the then chair, which was Chair Wolf, and I said, how do I get something, a proposal in front of the task force? And he's like, oh, take it through committee first. But then I was surprised to find later that some people are just like throwing items on the task force agenda that haven't come through any committee and that also have no explanation. And so maybe coupled with that, we could shorten, those conversations, or even take those items off the agenda. Maybe they should just be a, FYI in the packet, in submissions, here's something you should look at. You know what I mean?
Maybe they should go through our committee chair.
Well, they do. Oh, our committee chair?
Yeah.
A committee chair.
A committee chair.
Yeah,
Like if you wanted to put something on the main agenda, the committee chair has to actually put it forward for you. Like they have to approve it.
That makes
And
sense.
then it's just a funnel. Like it may not actually, you could still have someone like, could you throw this on the agenda for me? Like I could still say that, but there would still be a gatekeeper who could say no.
Or there would be some sense that what was being asked for was hashed through previously, and that there's some support to like bring it to the full board. So I just want to throw that out as another way to like maybe gain some focus in what comes ahead. But I do like the idea of maybe having time limits for some kinds of items and having a one go around rule with possibility of one extension or something. But I do think that like these things that get really long often get really long because people just don't want to give up their position and consensus is not being built, or they want to just,
And I personally find that really frustrating when they're like, when someone raises their hand, like, I just want you to know that I'm not supporting this. And then because I also like to say that when it's coming up, like, I'm like, wow, I really don't support this. But then that statement instigates an entire discussion of how we can all come to consensus.
But we also don't have to come to consensus.
I don't think we should either. Yeah. That's where the debate gets so long. It's just like, then don't support it.
No, I agree. And so I just think, the one go around, I don't know, the chairs seem to think that you really have to limit the speakers and not just try to use timing to put a pressure on the speakers. Because he didn't think that would be effective. And I feel like he probably knows.
I like the once because when you read through how the Board of Supervisors does it's a different context, what they're doing in their committees, what they're doing before the full board. They're not hearing complaints. This is complaint procedures. And so we have to adapt what they might do to something that, might work for us. So I could see why they would say member shall not speak more than once in any one debate on the same subject. I could see that we say more than once, with one exception, which is that except where they're actually making a motion. That to me is like, because I could see speaking and then I lose, I'm done. Maybe we just say, except for when someone is making the motion itself. I
would,
and then say once.
I still think twice, but I will support once. I will say, like, a compromise to my suggestion is twice, but you don't get to speak your second time until everyone who wanted to speak in round one got to.
That's also there in the BOS rules.
That's the next one. And so what we could do is take. Yeah. That's in the second part of this. So you like that?
Yeah, I think that works because that way people get a second chance, but they're not trying to deliberately dominate the conversation, which often happens.
Okay, so we could leave it at, well, what that does is it means you say like anyone who hasn't spoken, they get the chance for so-and-so.
Yeah, so what it says in the limitations on speaking of the Board of Supervisors is supervisors who have once spoken on a particular matter shall not again be entitled to the floor so long as any supervisor who has not spoken desires to speak.
Okay.
If they worded, we could take it right from there.
That seems like that sentence is, it seems like we're good with that sentence. The prior sentence, what changes does anyone think we want to make to the first sentence? It seems like we're either saying more than twice or we're saying more than once with the exception of making a motion or the making of motions. So maybe this whole paragraph, the only change we would make here today before we send it to the board is do we say speak more than twice and just leave it at that? Because Saul wants twice.
No, I will say once. I will say it is 2 times, but it's that they shall not speak again until everyone else has gotten a chance to.
Okay.
So that's my version. I think that now that I'm thinking about it, I think that's my version of twice that I'm comfortable with. It doesn't have to be twice full stop. I think it makes more sense the way that it's worded here.
Okay.
And I also, in terms of revision, it does say 10 minutes in there, which we probably should not.
I don't want 10 minutes.
Yeah.
Yeah, no way. If we give someone 10 minutes, they'll take it.
Discussion, right? But the only thing about having any minutes is somebody has to time these minutes.
In the administrative items, and we discussed that with Administrator Peterson about that you can do a clock for that.
Oh, so no timing of the amount anyone's speaking. We'll just leave it. You can
As
speak
the item.
once or twice, but we're not saying 10 minutes.
Yeah, no, for the minute, so outside of complaints, for the other agenda items, you could set a time of whatever, 30 minutes, pretend, 30 minutes. You can just set the timer, and then when it's done, let's just say it's a discussion and action item, then you have to come to a motion or leave it the way that
But you're not putting any limit on how many times someone can speak.
I don't have a lot to say on a lot of those items. It's just a few people that kind of,
Well, it doesn't mean you have to speak. I mean, you have a limit. That doesn't mean you have to speak.
But that way, if someone wants to have the floor, if 3 people want to have the floor, they're allowed to have the floor for 30 minutes. They just can't. That's my take.
Okay.
Are we ready to approve this 4-line paragraph?
Limitations on speaking.
Yeah.
I'm ready to approve it with the revisions we discussed.
Which revisions?
So I would approve it as saying, it says supervisors. So I'm going to revise this in, real time, but, Sunshine Board members who have once spoken. Oh, sorry. Another part.
I've got a version that is above. It's not 511 per se. It's the paragraph above it.
Okay.
I wrote that for us.
Oh, okay.
And
so
we can make changes to it. That's what I was thinking.
So I'm just gonna write it out. Hold on.
Because we can't change it on this file.
I would say, let me find it again. Okay, here it is. Here we go. Sunshine members who have once spoken on a particular matter. So I would say during deliberation, Sunshine members who have once spoken on a particular matter shall not again be entitled to the floor so long as any other member of the Sunshine Force who has not spoken desires to speak.
Sounds good.
Hold on. I'm looking at the rest of it. Let's see.
We don't really debate, so I think maybe that word
Right.
replaced by deliberation.
In the floor. Members shall then be offered the opportunity to speak one more time, and any further deliberation from the same member shall not again be entitled to the floor without a consent of the majority of members present. Would be like my way of saying that. Does that all make? Okay.
It might be how late it's getting, but I'm trying to put it in here.
I'm writing it out too.
Oh, then.
Well, no, I was.
I think the during deliberations needs to be at the top of the paragraph.
Yeah. During deliberations, Sunshine members.
You can just say a member
Okay.
shall not speak.
Who have once spoken on a particular matter should not, I'm taking this from the supervisors. During deliberation, members, just gonna do this, who have once spoken on a particular matter shall not again be entitled to the floor so long as any member who has not spoken desires to speak. And then members shall not speak more than twice on the same matter unless members shall not speak more than twice on the same matter during deliberation unless a majority of the board consents.
Aye. I'll take it. Yeah.
The matter is agendized only for discussion.
Oh, so we can't vote? Okay.
But
Okay, then you have time to refine.
no, that's basically, how should I email this to somebody? That's what it is. Or I can read it so you can write it out somewhere, but that's how I like it.
But we could put this on as our recommendations to the board. We don't necessarily, if we all consent to it. But yeah, maybe it's for discussion only. Okay.
Discussing now and then fine tuning.
Okay, and then next meeting. That's cool. Okay.
Okay, so that's my contribution. And that I still think I'll just suggest a 30-minute limit on other calendar items.
What you mean going outside of, see this, what we would be doing there is a little bit outside the scope of what, okay, let me take that back. All right.
No, I understand. Yeah.
Other calendar items, you want to put a time limit on them. And generally that's so that the meetings will not take so long. So what we need to do is figure out like where we put that into the rules. You know, does that go into the bylaws? It certainly doesn't go in here in section 11, hearing procedure.
So what I would say is I completely agree that we should stay within the scope of the complaint committee and what we're suggesting in terms of the complaint process. And I still suggest that we put forward this 30-minute idea.
Yeah.
Just do it after. Like you have these complaint ideas, and then you're like, and then when you suggest it, because I do not want to be the person making this presentation, but when you suggest to the full board, you say, okay, well, now that we've gone over and voted on each of these items, we do have a suggestion, even though it's a bit out of our scopes, like like that.
I don't think we have to necessarily be limited to our own procedures.
Right.
I think that, Chair Yankee wants us to be talking about anything.
Yeah.
That's gonna cut time. So I guess I'm just pointing out that these other things we're talking about are complaint procedure things. And that one is outside of complaint procedure things, although it's a good idea. I like
I
it.
think it's a good idea, but I also agree with your point that I think if we take too many things to the main board
Yeah.
at the same time, it just confuses the issue. And I think this is a very good change in and of itself.
Uh-huh.
And I think we can take it.
The 4 sentences.
Yeah.
Yeah.
Out the next thing next.
Okay.
Although it would just be a matter, it would just be right now, you would have to make it clear, this is for the complaints. This is for when a hearing is being held on a complaint.
Yeah.
This is how we think it should happen.
Yeah.
It's under our scope to suggest this.
It's under our scope.
This is our-
So, yeah.
I'm just.
I don't think that even matters really, because whoever's supposed to be doing the other stuff rules, they don't even meet.
Yeah.
So,
Yeah. Yeah, that's true.
And I still am on it, and it hasn't met for years.
Okay, I'm emailing the language to all 3 of you.
Okay, so we're on board for that. Now, are we on board for the 30-minute limit? The 30-minute limit on deliberation in the hearings on complaints. Or are we gonna just like take that 1 4-line change? And that's the only change we want to make. I just wonder if we're going to change like rebuttal to 1 minute or any of these other little detailed changes.
So I agree with Member Stein to keep it straightforward.
Yeah.
Number 1, I also think that I agree with you that you should introduce these things one at a time. So
Okay.
I actually want to see this one that we've discussed and made the lines for to push through.
Okay.
But if it doesn't,
Yeah.
then the alternative is a good idea as a backup plan.
Okay. Okay.
I will just say, I don't know if our chair would support it, because he is worried about too few members monopolizing the time.
Okay. Does anyone have interest? Okay, so maybe the idea is one thing and one thing only, and then we get it approved. If we're gonna go do other things, which would be contrary to that idea, do we want any of these time limit changes on the speakers? Whether it's their own presentation or their rebuttals. Now, I think we don't necessarily agree on whether we cut the 5 minutes down, which is fine.
No, I want it suggested.
I think it's a good suggestion.
Yeah.
The only one that makes me a little uneasy is the 1 minute.
The
But
rebuttal?
1 minute, the rebuttal, but I'm
Okay.
fine going from 5 to 3. I think most people don't take full 5 minutes. And, I think we've mainly read the complaints, and if they know that they have 3, I think they'll get their point across in 3.
Okay, let's do that. 5 to 3. And rebuttal, if you like, we could do 3 to 2. It probably
seems so fast.
does it. Okay. Yeah, and a lot of people, true rebuttal is like rare.
Yeah.
Usually they're just saying, what
I
they said before.
I just don't need rebuttal.
So, okay, 5 to 3, 3 to 2, done. We're not going to do the 30 minutes. We're not going to do that one. We're going to do the 4 sentences or the 4-line item. How about the last one, which is about a motion? Oh, after at least one motion has been made, 3 members may move to terminate deliberation on a matter. If the motion carries, all deliberation terminates and the matter is closed.
I like that idea a lot.
Okay.
I just, I feel like I've had several experiences of trying to make a motion and no one seconds it. So I don't know if it will really fly, but I don't mind trying it.
Okay. You would still you'd need 3 to
No, I don't.
make
I'm
the
just
motion.
wondering if you could really get it.
And I'm not sure how you get 3 because we can't really how do you?
I think that closing it is potentially a way to not get that specific measure passed. Because if people still feel strongly about it, you make a motion to close it. So it might be just three members may move to terminate debate and close or postpone the matter. Like they can choose either one of those options. So that way you can push it for time. That's my suggestion for that. And I want to also, not that I want to complicate things, but I'm not against the 30-minute thing, just only as an alternative.
Oh, okay.
Just bring it up if the other one fails.
Okay. Okay.
Well, it's not terminate it's just terminating the debate, and then you make a motion. So you're just basically
Oh, yeah.
calling a question, make a motion.
No, it says, and the matter will be closed.
And the matter will be closed. Yeah. That's according to, all debate on pending shall terminate. So I guess I wrote that in. But if we terminate debate
and it's just motion
deliberation, what is that? Then what happens?
And it's motions.
Motions only.
Yeah.
So we're back to the motions only thing. Okay.
I think that's a good idea.
Yeah.
And that's
I'll be interested to see if it ever can actually be used, but
it's not very diplomatic. So it would have to be in a situation.
It would be, because I feel like it's the times when I've been undiplomatic and I'm like, it's 1 a.m. I moved to end and nobody seconds it, So that's why I think it might not get seconded, thirded, but yeah.
Next time it's one and you do that, I swear I'll second it. Yeah.
I won't be there when it happens next time, and we'll have left on the record.
We could put that in. Yeah. All members named Saul will only attend.
I put that on the record already to the chair. This is when I will be attending until.
I have to just jump back and say I still like one go around more than two go arounds. One go around with potential. I mean, why not?
I forwarded the language to you, and and please, if it's one, then I will support that as well. I'm happy to get on board with it.
Still just discussion now, but we can.
Yeah, I think speaking once, and just putting your position out there, and then that the only thing left that you can do is make motions. That it actually doesn't feel that different than how I kind of think it should be, and how I probably sometimes go more than once. But I think usually I'll want to state my position or maybe not even state my position, but then it's all about, are we going into motion territory here? Mm-hmm. So I could see once, and then you can make motions. I could see that. So we need to decide if we want once or twice, but I guess I'm on board for the once.
I feel like once is probably enough, and it might actually have the impact, and it's justified, right? You just want to hear how everyone's thinking about it, and then you don't have to then go until you get consensus.
Yeah.
You just vote, and maybe a couple people don't agree. But
and we'll have less of this,
yeah.
Just blab.
As an aggrieved person who tried to propose making the meetings efficient last time, I would like to see this proposal pass, which is also why I would like to see twice. Possibly. Hey, I will support once if you want to go forward with it. Yeah.
Not at all,
but I'm just throwing that in there.
I get it.
Why not just say once? It doesn't pass, then come back and say twice.
Okay. I'm fine with that too.
Okay.
I'm on board with what works for you. Yes.
Yeah, and then we'll settle for twice. Okay. So what we'll do here is I'll put this on our next meeting. And we won't call it for discussion only. We will have language, and let's have our language ready to go so we can vote on it next time. And if we're going to do changes to the hearing times, 5 to 3, 3 to 2, that can be a separate motion, and we'll put that before the board separately. And then if this other item, which is outside of complaint stuff, we could put it on, let's talk about that next time, all right?
Why don't we do what you just said and then just save the other stuff for another?
Okay.
Well, we'll see how this
Good.
flies. But I like the other ideas too, motion to terminate debate, et cetera, et cetera.
Okay.
But let's get to that.
So next time we do this, it's not for debate only, discussion only. We're gonna be forwarding it, and so we're gonna be voting. Okay, thank you.
Noted.
I have one thing to add to this. And I've said it many times to you and several times tonight that I really enjoy this committee. I don't think that's a universal for people on committee. And in that way, we don't need to debate it tonight, but I think that we should discuss at some point putting rules up for other committees so that they also could enjoy not being potentially held into very long meetings that they don't want to be at either.
You think that maybe some of the other people don't like the committee meetings that they go to? Okay.
I don't think so. I've heard that.
Okay.
Just
Yeah.
But even having proposals like this, I mean, I'm not sure. I mean, I don't know. Something we could definitely look at, but it might be like somebody could then bring that into a committee and try to change however they do stuff in their committee too. But you can also look at it. Sure.
Yeah, I think that it's the same thing about diplomacy. Like they don't want to.
Yeah. We should maybe we should make it a thing that people switch committees. I think someone should be on a committee partly because of just the numbers. There's 3 committees, there's 11 people, 3 people, 4 people on a committee, and everyone should be on a committee. But people should move around. They should move around. Frankly, I would, if one of you guys wants to be the chair, I'll stop tomorrow. I'm fine with that. I've thought about why am I still doing the chair thing? I'd go on a different committee. That's fine. This is a good, we have, we rock. I'll put it that way. And so I don't necessarily want to go anywhere else. But yeah, we should probably encourage more of a flow.
Yeah.
Okay, items done. We're done with that one. Public comment?
There are no members of the public present.
Okay.
Item 13, announcements, comments, questions, and future agenda items by members of the complaint committee.
No, I don't have anything. Nothing.
Happy holidays.
Happy holidays is
Item 14, adjournment.
Yes.
All right.
The committee is adjourned at 10:24 p.m.
I know.
Microphones are off.